The Senate will come to order. Senators will be in their seats. The clerk will call the roll.
Alley, Baumgardner, Billinger, Bowers, Clays, Corson, Dietrich, Dahl, Erickson, Fagg, Fauscudo, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Holscher, Hershen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Sullentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Senators and their guests, please rise and give prayerful attention to the chaplain.
Please join me in prayer. Lord, without laws, without good laws, laws that come from you, in Proverbs 29:18, you declare that people will be out of control and going wild. But when we receive your laws and follow them, we will experience the delights, the joys of life. By divine determination, you have put all of us in these chambers, senators, secretaries, security, staff in every capacity, together to consider your laws in fashioning the laws that flow from here. According to your word in Romans 7, verse 7, you gave us your laws to use as a mirror so we could see for ourselves when we are going wrong. Like the pilots need their instruments to guide them in their flight, we need the principles of your laws to guide us in right decisions. Thank you, Lord, for the guidance you give us. Now keep us in alignment so we don't experience the judgment, the condemnation you mentioned in Isaiah chapter 5, verse 20, where we're calling wickedness as decent and calling that which is excellent as appalling. As it was with Ananias and his wife Sapphira in Acts chapter 5, they thought that lying and being deceitful was the way to go, until you showed them otherwise. Lord, you're yearning for a people of truth, of integrity. You said it is a wonderful thing for people to know and to keep your laws. Help us then to realize that we can't know them and be blessed by them unless we keep them. Therefore, as laws, policies and procedures are being studied, prompt us to regularly check the mirror of your word so we can get things right, so we can avoid duplicity and be known as people trying to follow the heart of God. My appeal to you, dear Lord, is in the precious name of Jesus. Amen and amen. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The chair recognizes the leader from Cali, Senator Alley.
Thank you, Mr. Vice President. I move the Senate suspend Joint Rule 4 for the purposes of considering the following bills: Senate Bill 39, Senate Bill 47, Senate Bill 60, Senate Bill 170, subbed for Senate Bill 238, House Bill 2026, House Bill 2077, House Bill 2079, House Bill 2121, and House Bill 2158.
You have heard the motion. All those in favor say aye. Those opposed, no. Motion carried. Now for the conference committee reports, I turn to the senator from Johnson, Senator Warren, on House Bill 2026.
Good morning, and thank you, Mr. Vice President. The Conference Committee report on House Bill 2026 contains law enforcement bills, and we'll discuss those now. So the first part of the Conference Committee report on House Bill 2026 creates the Certified Drug Abuse Treatment Program. The bill allows the eligibility for participation in a program for offenders who have entered into a diversion agreement in lieu of further criminal proceedings on and after July 1st, 2021. And this will help our law enforcement community by placing...
Could we have a little quiet in the chamber, please? Thank you. You may proceed, Senator.
Thank you, Mr. Vice President. And the bill allows for persons to be put into the Certified Drug Abuse Treatment Program once they have been duly certified by an assessment, and would help them with recidivism rates and not returning to jail. And it creates a standardized criminal risk need assessment. It also allows mental health professionals to participate in the program. If you violate the program and you are revoked, then the provisions of the diversion agreement that you entered into to get into the program would come into play, and the criminal proceedings would proceed accordingly thereunder. The bill also contains jurisdiction and supervision for 2003 SB 123 program. This was some criminal reforms that the legislature passed a number of years ago. It contains eligibility for the non-prison sanction of placement in a certified drug abuse treatment program that we were just talking about. Also in this bill is the riot and incitement to riot in a correctional facility. There have been problems with riots in Kansas in our correctional facilities, and the bill would increase and make it tougher on crime by increasing the criminal penalties for riot and incitement to riot when the crime occurs in a correctional facility. Right now, it's a misdemeanor offense if you participate in a riot or incite one in a correctional facility. This would raise it to a felony. The report also contains unlawfully tampering with electronic monitoring equipment, and the bill would bring in line the penalty for if you have found to have unlawfully tampered with your electronic monitoring equipment, your house arrest bracelet or whatnot, that it brings the level of offense in line with other criminal penalties otherwise in statute. And that is the content of the Conference Committee report, again brought to us by our law enforcement community. And for that, with that, I'll stand for questions.
Are there any questions? Seeing none, would you please make your motion, Senator? Motion first, and then we'll have the questions.
Thank you, Mr. Vice President. I move the Senate adopt the Conference Committee report on House Bill 2026.
Yes, the Senator from Wyandotte, Senator Haley.
Thank you, Mr. Vice Chair. Mr. Vice President, Mr. Vice Chair of Judiciary, and Mr. Vice President of the Senate, I just wanted to just kind of do a special emphasis. I know there's a lot of anxiousness to get on with other business in the Senate today, and some may have missed the significance in what the Senator from Johnson, the Chair of Judiciary, was saying about one component of this conference committee report, one that I'm particularly pleased to see come back to us and to have us hopefully adopt, and that is the diversion, the extension of diversion for drug abuse treatment programs, which has a bevy of implications for the freeing up of not only our prison bed space, but also towards getting those who suffer from drug abuse or addiction to get the necessary treatment, who have a diversion instead of a conviction. As the Senator from Johnson just said, Mr. Vice President, Kansas was at the forefront. We should all take a certain pride in that in the nation for what's been called Senate Bill 123, I think 15 or so years ago, when we adopted having those get treatment who have an addiction instead of incarceration. We became the blueprint for national models. And so I take particular pride in that. I hope we all do. And with this conference committee report, we're extending that treatment to those who opt to have a diversion. And I think it is a particularly significant and worthwhile endeavor that we are. So the other component parts that the Senator from Johnson outlined in the conference committee report, frankly, one is a little problematic, not the tampering one, the other one for the incitement, because those that are incarcerated actually conspiracies are alleged, who actually incites what ends up being some insurrection or ends up being a riot in our facilities might be construed depending on the counsel or who suggests that. I would have hoped that we would have dealt a little more closely with something that's laying on the table yet that the House passed regarding jailhouse informants. We have not dealt with that issue. And oftentimes, many people who are incarcerated will look at their fellow inmates and be the witness that one relies on for either lessening a sentence or extracting some punitive measure against someone else. That's missing from this conference committee report. And at the time that we are now enhancing the felony with the adoption of this report, for those who would suggest that, no, it was my cellmate who incited the riot and should do more time, I think there needs to be a stronger protocol. Perhaps we'll clean that up at some point subsequent, maybe as early as next year. So tentatively, I hope we'll all adopt for all that is good in this conference committee report, Mr. Vice President, and I do on balance support its adoption. Thank you.
Are there other questions? Senator from Leavenworth, Senator Pittman.
Thank you, and I agree with my good senator from Wyandotte here. I love the diversion pieces of this as we take care of giving our punishments out and then working with people to bring them back into our community as working citizens. If the carrier of the CCR could answer one question for me, Mr. Chair.
I'm certain she will.
Thank you,
Senator
sir.
Warren.
Appreciate it. Where did this language come from where we increase from a misdemeanor to a felony? Have we heard this inside of our judiciary or passed it out of the judiciary or this chamber before to have it included in the CCR?
Senator from Johnson, Senator Warren.
Thank you, Mr. Vice President. What bill are you referring to?
I'm sorry. It's a conference committee report that you just referred to. What is it? 2026, isn't it? Where we're increasing the the penalty where we have a riot inside of a correctional facility from a Class A person misdemeanor up to a level 8 personal felony if it's in a riot situation or a disturbance. Perhaps we can just answer whether we've even had a hearing on it in this chamber.
Senator Warren.
Thank you, Mr. Vice President. The House Bill 2191 is where the riot and incitement to riot in a correctional facility came to us from. It was introduced in the House Committee on Corrections and Juvenile Justice at the request of the Pawnee County Attorney there. And proponent testimony was presented in the House by representatives of the Johnson County Sheriff's Office and the Kansas Sheriff's Association, and led by the Leavenworth County Attorney. No other testimony in favor or against was provided, and it seems to be an important tool for our correctional facilities and for our law enforcement community to have. I did serve on the Joint Committee on Special Claims against the state and heard a lot of the claims that resulted from the riots in prison, and there was no opposition in the House, and it was not heard in the Senate committee.
Senator Pittman.
Thank you, Mr. Chair. Thank you for that, and I have great respect for my Leavenworth County District Attorney, of course. Great guy. And he has a great heart in terms of trying to protect our corrections officers and the prison systems and jails. I will say this body should be aware, though, we are putting a felony in place once again on people who are inside of these institutions who often have a downward spiral. And when we talk about incidents, I don't know if that's clearly defined in law. I will be supporting this, but I do have a lot of caution about this particular provision. I thank the good senator for explaining where this came from. Thank you so much.
Are there other questions? Senator from Sedgwick, Senator Pascadoe.
Thank you, Mr. Vice President. If the lady from Johnson would stand for a couple of questions, please.
She will. Senator.
Thank you. So I was around when we passed Senate Bill 123. Actually, there was a long debate here on the Senate floor from the previous senator that sat in the seat that I'm sitting in now, Senator Donald Betts, advocating for rehabilitation as opposed to incarceration. So if the good senator could share with me the major difference of what this legislation, House Bill 2026, the major difference of that legislation that we refer to as Senate Bill 123.
Senator Warren.
Thank you, Mr. Vice President. I was not a member of this body when Senate Bill 123 was passed in 2003, and I'm not sure about the question. I have not endeavored to undertake a comparison between this conference committee report and the full contents of 2003 SB 123. If there's maybe a specific question that I could look at.
Senator from Sedgwick, Senator Pascadoe.
Thank you, Mr. Vice President. So of course, Senate Bill 123 provides that rehabilitation and allows an individual to go to treatment and other things. And so it seems like this is kind of doing the same thing, which is good. So I guess I think the only difference in others might know, but, and I don't have that in front of me, but the agreement with the chief judges to, you know, weren't they already included? So, because if one is before the courts, that's a diversion piece where they would go. I was just wondering, you know, I support this 100%, you know, years ago and today. I was just trying to see what enhancement had we given that program, Mr. Vice President. And so Someone else may know that question, and I'll look into it further. But my second question, when we talk about increasing the penalties for those who are already incarcerated when a riot may occur within our correctional facilities, so how would we address those that are called lifers, who are they already in there? What additional punishment would be imposed upon them? Just curious, Mr. Vice President.
Senator from Johnson, Senator Warren.
Thank you, Mr. President. Excuse me, Mr. Vice President. I appreciate the clarification of the first question regarding what enhancement was made in HB 2026 Conference Committee report regarding 2003 Senate Bill 123. And the enhancement is that the bill would amend the law regarding eligibility for the non-prison sanction of placement in a certified drug abuse program. We saw that we're now, the piece of legislation includes the certified drug abuse treatment program and allow eligibility for that who've been charged with felony possession of a controlled substance and whose criminal history score is C or lower with no prior felony drug convictions. And it allows in this House Bill 2026 for the district court from which the defendant is on parole or probation assigned to a community correctional services program that the district court might transfer jurisdiction of the defendant with the concurrence of the receiving district court. So sometimes you're charged in multiple districts, and this would allow, again, tools for our law enforcement community for to transfer jurisdiction of the case to the most appropriate district court is what effect that, other than creating the certified drug abuse treatment program, it then allows the district court to transfer it to the most appropriate district court with the concurrence of the receiving district court and all parties, with the prosecutor, with the defendant, and all other stakeholders. And the other question is, what impact would the part of the conference committee report regarding riot and incitement to riot in a correctional facility, what effect of raising the penalty from a misdemeanor to a felony would have on those who have been sentenced to life imprisonment? And the bill amends the crime level offense, and there would be prosecutorial discretion what to do in that instance if there were someone who were participating or inciting the riot in the correctional facility and were to be charged and then to be sentenced. So it's, I would assume, would be on a case-by-case basis.
Senator from Sedgwick, Senator Pasquito.
Mr. Vice President, the gentlelady from Johnson really clarified and answered the question, so I have no further questions. Thank you so much.
Recognize the senator from Leavenworth, Senator Haley, for the second time on House Bill 2026.
Yes, sir. Thank you, Mr. Vice President. I'm Senator from Wyandotte, and my partner over here is Senator from Leavenworth, Senator Pittman. It did not opt. Just to add again to the question, Senator from Sedgwick, Senator Falsco, and the clarity that was brought by Senator from Johnson, Senator Warren. The peanut, if you will, the kernel for what makes this such an exceptional bill, at least in my estimation, it just comes down to two words, conviction and versus diversion. Senate Bill 123, which passed so many years ago, and Senator from Sedgwick mentioned her predecessor, also my former seatmate, Senator Donald Betts, who's now an attorney, by the way, in Australia. The conviction was so necessary to trigger Senate Bill 123. One would have to have gone through, a defendant would have to have gone through the process of being tried and found guilty of substance abuse or drug abuse or alcohol abuse and have to be convicted to be eligible for the provisions of 123. The distinction between then and what this conference committee report does is now for diversion. In other words, there may be a plea taken for someone charged with alcohol or drug abuse or substance abuse, and they may plead to a diversion, Mr. Vice President, and not have to go through the entirety of the court process, but to be found to be eligible for, we used to call it Senate Bill 123, I don't know what we're going to call those, and the court, through community corrections, and the court can find that they are eligible, that there's some persistent drug or alcohol abuse that is eligible for that treatment without them having to go through the full conviction process, which again will have an enormous impact on not only those defendants' lives, but also our bed space impact because they haven't been convicted. I hope that adds a little bit of clarity to the distinction that we're having here today, Mr. Vice President. Thank you.
Are there other questions? Senator from Johnson, Senator Holzer.
Thank you, Mr. Vice President. I do have a couple questions if the carrier would stand for them.
You will.
Thank you. My question is in regard to the riot provision in this bill. Was there any discussion in regard to what has been causing the riots in the prisons?
Senator Warren.
Thank you, Mr. Vice President. Again, the House committee hearing on this bill, there was proponent testimony presented by representatives of the Johnson County Sheriff's Office, the Kansas Sheriff's Association, and by the Leavenworth County Attorney. No other testimony was provided. So the criminal defense bar would have plenty of opportunity to come and provide testimony, as would any other group who we often see in committee, and there was no opponent testimony, no neutral testimony. We had proponent testimony from the county where the good senator is from, and in favor of it by the Sheriff's Office, and across the state of Kansas, the Kansas Sheriff's Association supported the bill. That's the information that I have. Thank you.
Senator from Johnson, Senator Holzer.
If I may follow up, what about the investigations that were carried out regarding the riots that happened at a couple of our prisons?
Senator Warren.
Thank you, Mr. Vice President. I don't have any of that information.
Senator from Johnson, Senator Holzer.
Very good, thank you. Because my concern is that we're approaching this from the wrong angle in the respect that from some of the information as a result of the investigation, from individuals who have family members in our prisons, it's been reported there aren't enough guards, especially during COVID. There were spacing issues, a lack of PPE, and other provisions provided. And at one point too, I believe in the summer, some of our facilities did not have running air conditioning in some areas, which in a situation like a prison could potentially cause issues with the crowding, the proximity of people to one another. So I think at the heart of it, what we're doing here is we're punishing on the back end versus addressing some of the issues on the front end in regard to appropriate equipment, appropriate numbers of guards, and even just like I said, the air conditioning, ensuring that that is working. So I do have, while I like the diversion part of this CCR and what that does, like I said, my biggest concern here is how we're addressing this issue and being extremely punitive when there are obviously some things we have potentially overlooked, possibly in regard to funding. Thank you.
Senator from Johnson, Senator Warren, do you care to comment?
Thank you, Mr. Vice President. Yes, actually the heart of it is personal accountability, personal responsibility. You can choose to participate in activities if you see riot going on or whatnot, no matter where you are. So this is about personal responsibility and personal accountability. And remember that this will come into play only after the person who is incarcerated in the correctional facility has gone through the legal process related to the riot and incitement to riot. So there will be the full trial procedure, the defenses that one would have available, and so the legal process would be borne out through this riot and incitement to riot in a correctional facility that this HB 2026 seeks to amend. Remember, it is already a crime to participate in a riot and an incitement to riot in a correctional facility. This bill only amends the offense level if you are convicted of that crime. And it, again, increases it from a misdemeanor to a level 8 person felony. Thank you.
Are there any other questions? Seeing none, we've had a motion. We'll hold for final action. We'll now turn to the senator from Johnson, Senator Warren, on House Bill 2077.
Thank you, Mr. Vice President. House Bill 2077 is another law enforcement conference committee report. I'm calling a law enforcement conference committee report because it contains a lot of tools, again, for our law enforcement community. The first part is the Kansas Criminal Justice Reform Commission has been addressing certain listed topics, and the bill amends some of those listed topics and would create new topics. I'm not going to go through all of those. They are in the bill. It does talk briefly about diversion programs. It amends the requirement related to analysis of diversion programs to require the commission to analyze those diversion programs utilized throughout the state and make recommendations for legislation regarding pre-filing and post-filing diversion and things of that nature. The bill also would amend the requirement related to review of supervision levels and programming for offenders on community supervision. So again, more law enforcement tools available for our communities throughout the state. It does address that the commission monitor the implementation of previously endorsed commission recommendations regarding monitoring as well. And if you'll remember, this did come across the Senate floor, and one of the things that we did was the report was required from the commission to be made in recommendations by December 1, 2020. Well, with the pandemic, they weren't able to meet and make their recommendations, so we have extended in the bill requiring the final report and recommendations to be submitted by December 1st of this year, of 2021. An important component of that piece is the Kansas Closed Case Task Force. If you remember, that was came across the floor here as well. And the bill would amend the law concerning the Kansas Closed Case Task Force. And it would rename that task force in the name of Alvin Sykes. It would rename it the Alvin Sykes Cold Case DNA Task Force at the request of the good senator from Wyandotte, Senator Haley. And it would extend the deadline for the completion of the protocol implementation plan relating to those closed cases, again, from a date in 2020, which was not able to have been met due to the pandemic, to October 1st of 2021. The bill also does amend the Kansas Crime Victims Compensation Board. The bill amends the definition of victim for the purposes of the Kansas Crime Victims Compensation Board. The bill does so by creating a new category of victim of, if you will, if a child, someone under 16, a child under 16 who has witnessed a violent crime when they were 16 or under, and it puts a deadline on when you have to file that claim as well. So it provides some more relief, needed relief for young witnesses of violent crimes. And with that, Mr. Vice President, I move the Senate adopt the Conference Committee report on House Bill 2077.
You have heard the explanation and the motion. Are there any questions? The senator from Lynn, Senator Tyson.
Thank you, Mr. Vice President. I would just ask the carrier if she would connect the dots a little bit for us. House Bill 2369 is listed in the conference committee report. However, I don't see a vote on it, so I'm wondering if that was included in House Bill 2082 or another bill.
Senator from Johnson, Senator Warren, are you able to determine that?
Thank you, Mr. Vice President. I'm looking, just a moment. $2369, Mr. Vice President, concerns the closed case task force, and it was put in the conference committee report, and we did have, must have been in another bill number. I would have to get with the reviser of statutes, and I can do that and report back.
I'll field another question, and we'll put that question on hold. The senator from Wyandotte this time, Senator Haley.
Thank you, Mr. Vice President. Well, actually, we'll start with trying to assist the senator from Lynn's question regarding the cold case task force. The DNA cold case task force was added by way of amendment, as the senator from Johnson said. It was a previous bill, the Criminal Justice Reform Commission and the DNA Cold Case Task Force, which has been renamed the Alvin Sykes Cold Case DNA Task Force by the Committee of the Whole here, were previously in a bill together. I think it was 2 years ago or 3 years ago that they were slated, both of these commissions, and actually there was another one. I think we had the Child Suicide Commission. There were about 4 of them in the original bill. Some of them were able to meet their requirements to submit a report or submit reports to the entire legislature in a timely fashion. 2 of them, that is the Criminal Justice Reform Commission and the DNA Cold Case Task Force, did not. The reports were not brought in as of last year, so this will extend until this year the original intent of the legislation to adopt some sort of policy guidelines through both the commission and the task force. And I was rising originally, Mr. Vice President, in support of the good work that the commission has done and that the DNA task force was starting to do. We are trying to put, and I'm pleased along with you, Mr. Vice President, to sit on the Criminal Justice Reform Commission. And as you can attest, I would hope, as I certainly want to this body, have met regularly trying to find some policies that would work toward our justice reform effort on the commission, who's chaired by the District Attorney of Sedgwick County, District Attorney Bennett, Mark Bennett. The DNA Cold Case Task Force met several times, chaired by Representative Fred Patton, and we're beginning to formulate means by which we can take DNA technology and apply that technology to cold cases. I don't need to share with you how effective it's been, Mr. Vice President, to find new uses for DNA and to apply that as it becomes available to cases that may have lain dormant for some time and to help resolve those cases. So I am pleased to see, though I regret, honestly, Mr. Vice Chair, that this extension goes until just December of 2021. I would hope there'd be an ongoing commitment from this legislature and from others to always apply or always have new ideas and opportunities be applied beyond just a report that would be put in December of this year, but that's what it is. So we'll just hopefully just have 6 more months toward this and maybe have to readdress it again next year. So I hope that clarifies a little bit of the question that the senator from Lynn and others may have as to what procedurally, in terms of standing committees, this, as well as other bills that we heard or amendments, had in terms of being vetted but coming directly to the floor for adoption by the full committee. And if there is some further question I can answer or inquiry I could respond to, I'd be happy to at that time, Mr. Vice President. Thank you.
Thank you. The Senator from Johnson. Senator Warren, do you care to comment?
Thank you, Mr. Vice President. I wanted to comment on the question from the Senator from Lynn, Senator Tyson, regarding 2369 and the Kansas Closed Case Task Force. Has been across this Senate floor before. We talked about it when it was incorporated into House Bill 2077 at the time. And House Bill 2077 originally came to this body after a vote of 120 to 5 in the House. And then when this chamber heard and 2077 here, we amended into it 2369 as it came out of committee, actually. And then on the Senate floor here, we amended it further by calling it the Alvin Sykes Cold Case Task Force. And then that passed this chamber with a vote of 39 to 1. So it has the contents of 2369 has passed both chambers. Well, 2369 as a standalone. Let me see. If, I think, well, so that's how we have it in the conference committee report at this time.
Senator from Lynn, Senator Tyson.
Thank you, Mr. Vice President. I would like to thank the chairwoman for her diligence and for finding that research for us. So thank you very much.
Senator from Johnson, Senator Sykes.
Thank you, Mr. Vice President. I, too, would like to say thank you to the Senator from Johnson for clarifying, but I also would like to say thank you to the Senator for Wyandotte for also answering that question and giving us the history of where this came from. Thank you, Senator.
Duly noted. Are there any other questions for the Senator from Johnson? Seeing none, we will hold for final action. Now I turn to the Senator from Sherman, Senator Billinger, on House Bill 2079.
Thank you, Mr. Vice President. House Bill 2079 is transferring duties concerning address confidentiality program, Safe at Home, and the registration of charitable organizations from the Secretary of State to the Attorney Generals. This was brought by both the Attorney General and Secretary of State. They've been going back and forth, and it just fits better in the Attorney General's office, especially when there's bad characters that need to be taken care of. It transfers the duties related to the registration of charitable organizations from the Secretary of State to the Attorney General, transfers the duties of administration, the address confidentiality program, Safe at Home, from the Secretary of State to the Attorney General. So it does both. The Senate version, we had an amendment put in that said no state agency or official shall impose an annual filing or reporting requirement on private foundations or charitable trusts that is more stringent than the requirements in Kansas or the federal law. This passed out of the Senate 37-3. I move the Senate adopt the Conference Committee report on House Bill 2079.
Senator from Sherman, would you care to make your motion before we open for questions?
I move the Senate adopt the Conference Committee report on House Bill 2079.
Thank you. Are there any questions from the Senator from Sherman? Seeing none, we'll hold for final action. I now turn to the Senator from Johnson, Senator Warren, on House Bill 2121.
Thank you, Mr. Vice President. There's a theme going here today, it seems. House Bill 2121 is another law enforcement tough on crime bill brought to us. The first component of it is something that has been discussed and on the minds of a lot of folks across Kansas, is regarding the crime of mistreatment of a dependent adult or elder person, particularly in a nursing home facility. So this creates a tool to make sure that some of our most vulnerable dependent adults and elder persons are properly cared for and looked after. And what it does is it amends the crime of mistreatment of a dependent adult or elder person to raise the penalty. And in law, when the lower the number, 1, 2, 3, is a more severe penalty than 5, 6, 7, 8. So it would raise from a severity level 5 felony to a severity level 2 felony when the crime involves infliction of personal injury, unreasonable confinement, or unreasonable punishment, and the victim is a dependent adult who's a resident of adult care home during the commission of the offense. It also raises from a level 8 person felony to a severity level 5 person felony when the crime involves the omission or deprivation of treatment, goods, or services that are necessary to maintain physical or mental health of the victim, and the victim lives in an adult care home. The bill also addresses absconding from supervision that this chamber has discussed before. We needed a definition. Our law enforcement made us aware, and our prosecution community, that we needed a better definition of absconds from supervision. And the bill would define the term to mean knowingly avoiding supervision or knowingly making the defendant's whereabouts unknown to the defendant's supervising court services officer or community correctional services officer. The bill also addresses amending law related to sureties and delivery of a person arrested. So we have bonds people who have sureties that need to be delivered to the proper jurisdiction, to the proper place, and this was brought to us by the law enforcement and the surety bonding community to provide that the person be delivered to the proper location. The committee report also addresses parole and post-release supervision guidance, and it requires the Secretary of Corrections to develop guidance for parole officers to use while supervising offenders on parole and post-release supervision. This provides some uniformity for our state and requires the Secretary of Corrections, who so far has not provided the guidance, and would be necessary and helpful for our law enforcement community. It makes a couple of technical amendments as well. And with that, Mr. Vice President, I move the Senate adopt the conference committee report on House Bill 2121. And I'll stand for questions.
Are there any questions from the senator from Johnson? Senator Warren? Seeing none, we'll hold for final action. I now turn to the senator from Cherokee, Senator Hildebrand, on House Bill 2158.
Thank you, Mr. Vice President. On the House Bill 2158, it is the State Child Death Review Board, and it also contains, that was House Bill 2158. It also contains Senate Bill 170. It was the Advisory Committee on Trauma. House Bill 2088, commonly known as Adrian's Law. Adrian's Law is where you have to have physically see a child if you are in law enforcement or a caseworker going out to investigate child abuse. 2115 was a Joint Committee on Child Welfare System Oversight Committee. And 2116, eligibility for child care assistance. And I move the Senate adopt the conference committee report on House Bill 2158.
Are there any questions from the good senator from Cherokee? Senator from Wyandotte, Senator Haley.
Thank you, Mr. Vice President. Just wanted to thank the senator from Cherokee. Thank you. been there many times. Cherokee is a wonderful county. It is also the Bourbon County there, Fort Scott and things. But the senator from Cherokee for bringing this conference committee report. I especially want to emphasize the appreciation to Senate leadership on both sides of the aisle for keeping the commitment to include what was dubbed in the House as Adrian's Law that passed, I believe, unanimously in the House, but had gotten hung up here, which we were attempting to amend in to Germanity. And it did. But thank you to the leadership for keeping that commitment to see the bill that passed on the House side for Adrian's Law. What Adrian's Law will do, and it came out of just a heinous example of it, because law enforcement was called out to look at the welfare of a child and did not physically see the child. They were given the assurances by who turned out to be the parent, guardian, abusers that the child was all right. And given those assurances, law enforcement did not see or follow up. The child ended up sadly deceased and left for feed for livestock, actually. And it was a horrible, and still the details remain. So this won't happen again in Kansas with the adoption of that. The advocacy on the House side, bipartisan advocacy, especially Representative Lewis Reese from Wyandotte County, who shepherded this for many years through the process, and now, again, with our Senate leadership keeping the commitment to the amendment that we attempted to adopt. I want to thank the senator from Cherokee for bringing this conference committee report forward, and I hope that we will join unanimously in its adoption. Thank you, Mr. Vice President.
The senator from Cherokee, do you care to comment?
I just appreciate the good words from the senator from Wyandotte County.
I now turn to the senator from Wyandotte, Senator Petty.
Thank you, Mr. Chairman. I too want to thank the senator from Cherokee for the work that went into this conference committee report. There's a lot of really good things in here when it comes to children and families in our state of Kansas. The Senate Bill 2116 that exempts the 20 hours per week work for needy families that do provide child care assistance or foster care assistance is really important, as well as the original bill, which was the 2158, the Child Death Review Board. There was an item that was added onto that here on the floor by myself for allowing any city or county that presently has a Child Death Review Board to have access to the information. And that's very important to Wyandotte County because they do have one in place. And just as a good senator from Wyandotte mentioned about the Adrian's Law, that would be one of those in the past deaths that we looked at too. But unfortunately, we have had an increase in youth deaths in the last few years. Last year, 5 in my district alone. So it's important to be able to look for reasons for what are some of those reasons, whether family or community they're related, and how we can address them. I know that there's been a lot of work that was done on 2115, and that encompasses more than just this year for the Child Welfare Oversight Committee. And so I'm glad to see that included in this bill. The conference committee worked diligently, and the chair was very effective in making sure that things moved along so that we could get out a good conference committee. I want to thank you for your work.
Senator from Cherokee, do you care to comment?
I don't think I could top that. Thank you.
We will hold for final action. We are now ready for final action. On this roll call, we will take the following. House Conference Committee reports on House Bill 2026, House Bill 2077, House Bill 2079, House Bill 2121, and House Bill 2158. The clerk will read the titles.
House Bill 2026, an act concerning crimes, punishment, and criminal procedure. House Bill 2077, an act concerning crime-related task force and commissions. House Bill 2079, an act concerning state offices. House Bill 2021, an act concerning crimes, punishment, and criminal procedure. House Bill 2158, an act concerning open government.
The clerk will call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Fagg. Faust-Godot. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Olsher. Hershin. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson. Petty. Pittman. Pyle. Reichman. Steffen. Straub. Zellentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Has every senator had the opportunity to vote? The senator from Sedgwick, Senator McGinn. Senator from Cali, Senator Alley. Are there any other changes of vote? Does any senator wish to explain their vote? Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. Vice President. This isn't a change or a explanation of vote, but a change of vote. I changed my vote from pass to aye.
Senator Billings, you have, okay. Any other explanation of vote? Does any senator wish to change a vote? The clerk will call the roll and tally the vote. 39 having voted in favor and 0 against, House Bill 2077, House Bill 2079, House Bill 2121, and House Bill 2158. 36 having voted in favor, 0 against, House Bill 2026. These measures having received the required constitutional majority are hereby declared passed. We now will turn to the good senator from Lynn, Senator Tyson, for a conference committee report on Senate Bill 47.
Thank you, Mr. Chairman. I move the Senate adopt the conference committee report for Senate Bill 47. I'll stand for, do you want me to explain now?
Would you please?
Thank you. Thank you, Mr. Vice President. As with most tax conference committee reports, there are a lot of moving parts in this report, many which the Senate has seen before. Senate Bill 47, the Taxpayer Protection Act, would require anybody getting paid to file an income tax return to meet certain qualifications. It would help cut down on fraud and ensure taxpayer protection. It also includes Senate Bill 71, which passed this chamber 39-0. The Senate position was the Eisenhower Foundation tax credit program. The House took a position and amended Senate Bill 71 to add a tax credit program for Friends of Cedar Crest. We accepted that offer in committee, conference committee. There's also a position that passed this chamber for the single city port authority for a tax credit program. It's an extension of the program. The Senate did sunset that program and the House accepted that position. The Rural Opportunity Zone was included in this negotiation. The House offered their position. The Senate chamber did not have a position on that. However, the committee had a hearing and worked the bill. So we did offer a couple of the items from the Senate position from the committee. One of those items was accepted, and that is to increase the number of counties so that if any county with a population equal to or less than 40,000 would be considered a rural opportunity zone. The program will sunset in 2023 so that this program will be looked at again next year. The conference committee report, the House accepted the position that any victims of stolen identity are not liable for any income tax in the state of Kansas. We also extended the corporate deadline, filing deadline, 30 days past the IRS deadline. We will automatically match the federal deadline for individual income tax returns from now on in the state of Kansas if we can get this into law instead of changing federal deadlines in statute. We also provided, the Senate passed this, the House accepted the position to allow employers for calendar year 2021 and 22 to treat employees who are working remotely as if they are working in their primary work, their location, remote working. That was a result of the pandemic. The governor had an executive order on it, and we just codified it with law. Everything would take a date, the effective date would be the Kansas Register, except for the Taxpayer Protection Act. That would be January 1st, 2022, because of current filings going on. With that, I'd stand for questions, Mr. Vice President.
The Senator from Douglas, Senator Holland.
Thank you, Mr. Vice President. I very much appreciate the chairwoman's description of the conference committee report. I'm also pleased to see we brought a little bit more standardization to the ROS portion of that, of having the definition of the counties being up to 40,000, I believe, to qualify for that program versus kind of a willy-nilly approach before. So I'll be fully supporting this and ask the body to do so. Thank you.
Are there any other comments? Senator from Johnson, Senator Olson.
Thank you, Mr. Vice President. You know, ROS, I didn't speak a lot yesterday, but I want to speak about this bill because of the ROS piece. When it originally started, it was started for, you know, counties that had lost 10% of their population. And this was to benefit and get growth back in their communities. And then the next year, a few more counties got added. Next year, a few more counties got added. Next year, a few more counties. Now we added another 15. We're up to 95 counties out of 110 or 105 counties. And so we're down to only 10 counties left. I don't know why we just don't take the program clear across the state and make it uniform to every Kansan. But I think the whole program has kind of lost its direction. It's to try to get population back into them rural areas. You know, one thing about this place is when you have money on the table like we did yesterday, everybody tries to get their hands in and give it out to their district. You know, and this has been no different. And we wonder why, you know, our school education system, how many times have we amended that? How many times have we amended the tax code? We wonder why it's a mess, because everybody comes in and gets their little piece of the pie. I'm sure the original bill was pretty good, but then they just keep carving out a little piece, a little piece. You know, I think we'd be a better state if we would just go through our tax policy, our education policy, and redo it, and a lot of other things, because we've got so many carve-outs that we've really messed up the original intention of what we're doing. And, you know, this is just another camel under the nose of the tent where we're adding 15 more counties. Why don't we do it for everybody? Why don't we make it fair for every Kansan? If it's so good, it works so great. And, you know, same way with our tax policy. Why don't we really look at it and let's, you know, there's what, $7 billion exempted? I mean, there's some more exemptions. Hey, there's some tax credits in here too. But, you know, why don't we find what's fair for every Kansan, every business, make sure the people should be paying taxes, should be. Why don't we go back and look at our education, you know, formula that was done in '92. It's probably got 30 amendments to it by now. And, you know, the state's changed a lot. The population's changed a lot. You know, I want to fight for rural Kansas when, you know, we do a bill like that and then we just keep expanding it. It makes it hard for rural Kansas to have something that is just for them, that can help grow their population. So I'm going to support the bill, but this is the symptom of the problem, like yesterday. Everybody trying to grab the money and spend it. So thank you.
Senator from Lynn, Senator Tyson, do you care to comment?
I would like to. Thank you, Mr. Vice President. You know, I appreciate the comments. He's spot on. I've said it before. I absolutely agree with the senator. In fact, that's what we did with property tax. We took a different approach to try to find problems. And it's interesting that he bring that up, because it sounds like he heard a conversation that the House chairman and I had the other day. We're actually going to request an interim committee to start that discussion and start working on the language so that we're not picking and choosing winners and losers, so that you don't have to have a lobbyist to come up and get a tax credit. The tax code absolutely needs cleaned up. I completely agree with him. We need to do it for education also. We've started that effort, as we did with property tax, going around, everything's on the table. And we're going to start it for energy too. I love the philosophy, and we need to keep that momentum going. So thank you for the senator from Johnson and his comments.
Senator Holland, I will get to you in just a second. Senator from Johnson, Senator Olson.
Yeah, I just want to go ahead and respond to that since I was mentioned. I've been saying it for years on the Senate floor, so there's plenty of recorded record that I just didn't hear that the other day. But I just wanted the new people to hear that. But yeah, so I just didn't hear that the other day. I've been saying it for a long time. Thank you.
Senator from Douglas, Senator Holland.
Thank you, Mr. Vice President. And I just want to reiterate, you know, representing counties, Douglas and Leavenworth, that don't currently participate in the RAWS program. I've done some reflection on this, you know, being on both tax and commerce committees. I see both tax policy, I see commerce policies, and I've been on both those committees for several years in the Senate and the House. And you know, we definitely have a depopulation issue, unfortunately, for the vast majority of counties in this state. I support the RAWS initiative from the perspective of addressing basically the flight out of these out of our rural counties. It's a very incredibly serious issue. I think we need to periodically ask, you know, the policy pieces we have in place to address the issue, you know, are they effective? But make no mistake, what RAWS is trying to do, you know, is very much needed when we look at population migrations in this state. As I've said to many before you ad nauseum, by 2030, Northeast Kansas is going to have over 53% of the population in the state. I believe South Central is going to have somewhere around another 25, 27%. And so the vast majority of the counties have and will continue to shed population. You know, when you go back and look at the original RAWS program, and I've been around here long enough to know this, when you look at the original map of the counties, they were virtually just all in western Kansas, and for good reason, because there was massive population flight out of those counties, Mr. Vice President. And so, you know, on the one hand, it's easy to say, well, you know, other counties want it on board, you know, is just everybody grabbing it. And I appreciate that perspective, because that is relevant on a lot of programs we have. But make no mistake, if you really divide our state up into like 6 different regions, Northeast is growing, South Central is basically kind of treading water, maybe up a little bit. But the other 4 regions of the state, North Central, Northwest, Southwest, Southeast, they are shedding population, and they will continue to do so in the future. And so when we have these other counties asking to get it on board, you know, a lot of them are losing population. So I think it's important that as we implement these programs, it's not questioning the need for it, but just being sure we keep them relevant. And I look forward to working with other members of this chamber to specifically address that population flight out of a lot of our rural counties. Because to make no mistake, to move this state forward, we have got to address it, you know, through our budgeting policies, through our taxation policies. It's critical that we do that. Thank you, Mr. Vice President.
Senator from Lynn, Senator Tyson, do you care to respond?
Thank you, Mr. Vice President. I will respond to the earlier comment. I appreciate the rankings comments, and I was trying to make light when I said that he might have heard a conversation between myself and the House Chairman. You know, it's that time of session. Everybody's been working very diligently. We've all I did not mean to offend anybody if they took offense to it. I know that everybody realizes the tax code needs work, and that's what our attempt is to do. So thank you, Mr. Vice President. And I hope that everybody will stand in support of Senate Bill 47. I want to thank the ranking, the vice chair, and all the committee in this chamber for their work on tax this year.
Seeing no other questions, we'll hold for final action. I now turn to the senator from Johnson, Senator Warren, on Senate Bill 60.
Thank you, Mr. Vice President. The theme continues. Senate Bill 60, the conference committee report on it is again tough on crime, law enforcement provisions, and provides some relief for our crime victims here in Kansas, some tools. The first piece of the conference committee report is regarding Senate Bill 60, and the bill would amend the jurisdictional application of our Code of Criminal Conduct. It would amend the statute, making proximate result better defined so that in law, proximate result would mean any logical effect or consequence of an act, regardless of whether the statute had specifically prior to the enactment had said that. And when we talked about this, when it last came across the Senate floor, was when we were talking about the unemployment fraud that has been occurring in the state of Kansas. Sometimes the bad actors are not within the state of Kansas, but the victim is, and this would provide some prosecution tools for our law enforcement and our prosecution community to bring those bad actors to justice here in Kansas and provide some help for our victims here as well. The second piece is psychological or psychiatric examinations of crime victims. This would provide a ban on requiring a psychological or psychiatric exam of a crime victim in a criminal case. And that would be important protection for our crime victims here in Kansas. The next piece would amend the definition of the crime of sexual battery to make remove the element requiring the crime be committed against a victim who is not the spouse of the offender. So it would remove the spousal exception to the crime of sexual battery. The next piece is brought to us again by our law enforcement community. There's rampant auto theft in Kansas, and so this bill would amend the offense of fleeing or attempting to elude a police officer to also bring the language more in conformity with other pieces of the criminal code to knowingly driving, knowingly departing lanes, knowingly driving through an intersection causing evasive maneuvers and things like that. The bill amends the penalty as well. Again, a tough on crime piece. The other piece of the conference committee report creates a new crime, again, making it tough on crime, the crime of sexual extortion. Currently in law, we have crime against extortion if you're extorting money from someone, but if you are extorting such things as pictures from someone or sex acts from someone, this would make it a crime to do so. And the crime would be a level 7 person felony if you have the intent to coerce that person to engage in sexual contact or other things of sexual natures, or to produce a video or a picture. And if your actions actually cause the person to engage in those behaviors, that is a higher level of offense, a higher level felony. It would be a 4-person level felony. And with that, Mr. Vice President, I move the Senate adopt the conference committee report on SB 60. And I'll stand for questions.
You've heard the explanation and the motion. Now are the questions. The senator from Leavenworth, Senator Pittman.
Thank you, Mr. Chair. I'll have a question here in a second. I realize we do have this tough on crime attitude. I also have an awareness of the riots that we had last year as we go into this. And I always push for more criminal justice reform, and I've been talking a lot about felonies on the floor. And I was looking at this and I noticed that we're increasing penalties from misdemeanors to felony once again. And I honestly come into this body and I've learned things about strict scrutiny and how it applies to our Second Amendment laws. And I learn more and more from our good senator and judiciary and some others that are in the law enforcement. And when we look at what was included here, House Bill 2093 about eluding police and driving down the wrong lane and these types of things, I see that we're increasing the penalties again. And I'm confused on a few points, and one of those points, Mr. Chair, if the chairwoman could answer, would be the, I don't understand what it means between knowingly, willingly, intentionally. And I know there was some discussion, and I'm a little concerned about those words, and I just want clarification for the body as we look at how that, if we're going down, it looks like any other lane or an interstate or anything like that, what is the difference so that we can understand what are these changes between willingly and knowingly and intentionally? If the chairwoman could just clarify that, because I am a neophyte in this area.
Senator from Johnson, Senator Warren.
Thank you, Mr. Vice President. I am not going to speak on behalf of the court systems or how those terms are used in law. That's not what I'm going to do here today. It was the feeling of the, and not the feeling, but the work of the Senate Judiciary Committee and again the Conference Committee to more provide uniformity in the law, in the criminal code, with the change willfully and knowingly. And again, that would be a term and a factor that the fact finders, the jury, would assess whether it was knowingly or not.
Senator for the 11th, Senator Pittman.
Thank you. Yeah, it does seem, when we were reviewing this, it just seemed if someone unintentionally takes a wrong turn, whether they'd be potentially creating a personal, a severity level 7 if they'd accidentally done this before, level 7 person felony. It's concerning whether that's, it seems very broad. Some of these things seem like they could be potentially confusing for those who might be pulling to a safe spot and then be convicted of some of these crimes. But I guess I was a little bit, I don't understand the difference in the intentionally and knowingly piece of it. I guess that's something I'll have to pursue at another time, Mr. Chair. I appreciate the good chairwoman for at least talking to it. Thanks.
Senator Warren, any response?
Thank you, Mr. Vice President. The definition of culpable mental state and the definition of knowingly is found at KSA 21-5202. And that would be what would be applied in a case where someone were to be involved in the criminal process as we're talking about here.
Senator from Leavenworth, Wyandotte, Senator Haley.
Vice President, I don't know if this portends redistricting plans you might have for me or not. I remain from Wyandotte for now, but you might have some inside track that I should probably pay close attention to. But on behalf of the good people of Wyandotte who bring me here, I just wanted to rise and to say to the senator from Johnson on this conference committee report, one component piece here that we should all take a particular amount of pride in is the expansion of making sure that spousal abuse, the battery of spousal abuse, domestic. I've long been a champion of not giving safe harbor to those who, by virtue of their domesticity or their domicile, are able to suggest that they're immune from battery. We have a large problem in many of our communities with domestic abuse. And Mr. Vice President and others, I know we hear about that from time to time, but much of the backlog that we have from cases that cannot be addressed in Kansas may be alleviated by this because, frankly, law enforcement has not been able to touch those allegations of domestic abuse. Sometimes it's as clear as a bruised person coming and saying, I've been abused, I've been struck, I'm the victim of a battery, and the immediate affirmative defense is, well, this can't be prosecuted because we're married, or because even we live together. And this has long troubled me, as it should others. There are some who would provide safe harbor, even now in the legislature, that a defense to these allegations of battery are all right. They're okay because persons are married. That's always struck me as odd. I should say that part of the backlog, even for our sexual assault kits, which are taken, have been left lying on the shelves. And this is something we haven't addressed either, and it's something else that the senator from Johnson, the chair of Judiciary, I would hope would undertake to get the backlog of our rape kits whose evidence are waiting to be evaluated and potentially prosecuted, to get that cleared up. But many of them still sit there because they don't take the kits because the interaction, the allegation of rape, the allegation of battery or of abuse occurred between two individuals who have a level of domesticity. I'm very concerned about this, Mr. Vice President, and I'm so glad that this is a part of this conference committee report. As I said previously, we've left a lot of things that came over from the House, like the backlog of rape kits that came over here, is left dormant in the Senate. As I mentioned earlier, the jailhouse informants came over from the House. We should be doing something about that as well, left dormant in the Senate. But I'm very pleased that we're at least doing something about oftentimes these individuals who are in a bad domestic relationship and find themselves the victim of being battered time and again with no recourse available within the law. So I just want to say how pleased finally I see us addressing this issue, at least as a part of this conference committee report. We're doing good things here now, Mr. Vice President, at least in this particular one, and I just thought I would share my concern and part of it being addressed by this report. Thank you.
Senator from Johnson, Senator Warren, do you care to respond?
Thank you, Mr. Vice President, and I would thank the senator from Wyandotte for his complimentary remarks, and he is a member, the ranking minority member on the Senate Judiciary Committee. The committee has been very busy this year, very busy. We didn't get to all the bills that we would have liked to. We've been working on a number of issues that have come across the Senate floor. Some of the bills, the proponents ask, well, they're not quite ready yet, so would you wait till next session? So we work with stakeholders as well on those bills, and so they'll be, there's next session as well. So we've had a busy session, and I would thank the senator for acknowledging that as well. Thank you.
Turn now to the senator from Johnson, Senator Holster.
Thank you, Mr. Vice President. I also want to voice support for this provision. We have a lot of work to do when it comes to our laws and making updates, specifically when we talk about laws in regard to sexual violence and victims of crime. I'm very appreciative of the inclusion of removing the spousal exemption in this CCR. I know we had a packed agenda in Senate Judiciary this year, and there wasn't time for my bill on this topic to be heard, so I'm extremely appreciative of the House moving their bill and thankful to the Senate chair and other members for getting it included in the CCR. This is a great move for helping victims of violence. Thank you.
Senator from Johnson, Senator Warren, do you care to respond?
Thank you, Mr. Vice President. Just appreciate the comments from the senator.
Seeing no other questions, we will hold for final action. I recognize now the senator from Cloud, Senator Bowers, for a point of personal privilege.
Oh, thank you, Mr. Vice President. And just we'll take a break just from legislative activity, just a second. I'd like to introduce you to my daughter behind me. This is Haley Bowers-Lowell. She's a new doctor. She will be practicing at Community Memorial Healthcare in Marshall County, that's Marysville. But before that, I wanted to talk just a second about the brain drain that we've heard here in the Senate and how we're losing young people to other places in the United States. But I want to brag on a moment on a program that kept this young lady in rural Kansas. And let's see, Senator Haley, you would have been around in 1997, I believe, and you would have voted on this legislative piece of action that created the Scholars in Rural Healthcare program, and you might have remembered it as Scholars in Primary Care program. So just to mention this rural healthcare program, these kids are taken when they're sophomores in college. They commit to a 2-year program. They are saved a slot in medical school at KU, and then they're required to have 200 hours of shadowing, at least 3 reports, and regular meetings with their colleagues. And they take a dozen to 14 young people every year to do this. And then the most important part is they're accepted into medical school with their proper MCAT score. So it's a very popular program, and I just want to bring Haley here. She has promised to come back and be a doctor of the day. So we could go up and get her blood pressure taken, which I know this building can cause that. So we'll see her next year, but I want to take the opportunity to let you know there are good kids who are staying in Kansas, and we are doing good legislative programs that we aren't losing the best of the best. So keep an eye on Haley, and I'll let you know when she's upstairs next year for us. So thank you very much.
Welcome to the Senate, and good to have you here. Thank you, Senator Bowers. Before recessing, are there any announcements? The Senator from Butler, Senator Masterson.
Thank you, Mr. Chairman. I was given the task of announcing there is going to be a luncheon on parental educational choice hosted by the American Legislative Exchange Council at 622 Southwest Van Buren, block and a half north here at noon. And then also a reception they are hosting 5 to 7 down at the country club at 5 tonight as well. Thank you.
Are there any other announcements? Seeing none, I'll turn to the leader from Cali, Senator Alley.
Thank you, Mr. Vice President. The House and Senate Fed and State Conference Committee will meet upon a recess in room 144S, and it will be discussing House Bill 2137, House Bill 2252, and Senate Sub House Bill 2138. And Mr. Vice President, I move the Senate recess until 2 p.m.
You've heard the motion. All in favor say aye. Those opposed, no. The motion carried. The Senate is recessed.
I'd like to announce that the Senate Ways and Means will meet at 1:30 in our usual room, 5th floor. Senate Ways and Means will meet at 1:30. Thank you.
Senate will come to order. Back on conference committee reports. Chair, Senator from Cherokee, Senator Hildebrand on Senate Bill 170.
Thank you, Mr. Vice President. Senate Bill 170 is, the contents are no longer there. What is inside Senate Bill 170 now is House Bill 2209. That was the PSY Compact, the Psychologist Compact, and House Bill 2279, which was the Physical Therapy Compact. And I move the Senate adopt the conference committee report on Senate Bill 170.
After the explanation and the motion, are there any questions? Seeing none, we will hold for final action. I turn to the Senator from Cherokee, Senator Hildebrand, on Senate substitute for Senate Bill 238.
Thank you, Mr. Vice President. Senate Bill 238 is a little bit more complicated than what Senate Bill 170 was, just because it's a lot of information in it. Senate Bill 238 just updates the Pharmacy Act for the state of Kansas. A lot of language. It does have provisions in it for telepharmacy. That's probably the biggest change. And inside of it, we also have House Bill 2280. Includes rules and regulations to adopt fees for actually, I apologize, that's not in there. We took that out. But House Bill 2234 is the EMS Act. It clarifies the oversight by alternate appointment procedures for our medical service directors. And I move the Senate adopt the conference committee report on Senate Bill 238.
Having heard the explanation and the motion to move, are there any questions from the Senator from Cherokee? Seeing none, we'll hold for final action. Excuse me, the Senator from Wyandotte, Senator Petty.
Thank you. I just wore this flowerful top, so you might notice me, but I guess it's that light's still in the way. It's
nice rhythm.
Yes. Well, thank you for the recognition. And I do thank the chairman from of Public Health from Cherokee for his explanation. I think this bill also includes some changes when it comes to the EMS Act as well, and that because of some outdated references there, and it certainly does provide for telepharmacy within the legislation as well. So a good piece of legislation. I was glad to be a part of it. Thank you, Mr. Chairman.
Senator from Cherokee, do you care to respond?
I just appreciate, I believe this is the last CCR that I am carrying unless something else comes out. I would just like to take this opportunity to thank my conference committee, our assistant, our vice chair, and our ranking. A lot of help and a lot of wisdom when we were in conference committee, and my committee as a whole. I say this, I am very thankful for each and every one of the members that we had. They all brought different perspectives to each bill, and all the input was definitely creative. And even though we didn't always agree, we always listened and took everybody's comments. So with that, I move to the Senate adopt the conference committee report on Senate Bill 238.
We will hold for final action. Now we move to the motions to concur. I turn to the Senator from Sedgwick, Senator Kershaw, on Senate Bill 39.
Thank you, Mr. Vice President. We are going to take up Senate Bill 39. That bill refers to the Animal Health Commission. And when we're talking about Animal Health Commission, it's with livestock on one side, and we have the domestic and animals on the other side. So it covers all of that. And what we need to do, first of all, is that there are 2 renewal dates in the bill, that one on June 30th and one on September 30th. We're going to strike the June 30th one, so there's only one left. It's just causing confusion to have 2 different renewal dates for people who, those who turned in for license permits and those kinds of things when they renewed them. So there'll be one date on September 30th. The other part of the bill is involves with ear tags, and on that side, and what you notice in the bill, they talk about young animals and immunizations. The truth is that most livestock are immunized when they are in the younger stages, and for cattle, it's just a small band about the size of your little finger that's placed in there with a number on it. Keep track of it. What this deals with in our report in Senate Bill 39 is we're adding a different type of tag. It's called a radio frequency identification tag. Almost the same size as a traditional tag, but it has the ability to track and keep the location of that animal no matter where it goes. And people are adapting to it because for biosecurity and health reasons, if there was an outbreak of mad cow disease, all these cattle can be identified wherever they've been in their lifetime if they have that tag in their ear. So the herders and the ranchers and people who raise cattle, it's to their advantage to use this service. We're going to, the tag is supposed to last for a lifetime. If it stays in there, the only flaw, once in a while one of those comes out, but we still have the record. So with that, I will, what do I do next here? I make the motion that the Senate concur on the House amendments to Senate Bill 39.
You have heard the explanation and the motion. Are there any questions from the senator from Sedgwick? Seeing none, we will hold for final action. Under consideration of appointments, the chair recognizes the Assistant Majority Leader from Cali, Senator Alley.
Thank you, Mr. Vice President. In compliance with Senate Rule 55, the appointments on page 2 of the calendar are ready for consideration, and I stand for question.
Are there any questions? Seeing none, you may move the appointments.
Thank you, Mr. Vice President. I move the appointments be confirmed.
We'll hold for final action. We are ready for final action. On this roll call, we will take the following: the conference committee reports on Senate Bill 47, Senate Bill 60, Senate Bill 170, and sub for Senate Bill 238, and the motion to concur on Senate Bill 39, and the appointments on page 2 of Berry, Sanchez, Spriggs, and Bencham. The clerk will read the titles and the names.
Senate Bill 47, an act concerning income taxation. Senate Bill 60, an act concerning crimes, punishment, and criminal procedure. Senate Bill 170, an act concerning public health. Substitute for Senate Bill 238, an act concerning health and health care. Senate Bill 39, an act concerning agriculture. State Banking Board, Mary Berry. Kansas Human Rights Commission, Alicia Sanchez, Nathan Spriggs. Kansas Public Employees Retirement Board of Trustees, Kathleen Von Aiken.
The clerk will call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Corson. Petrick. Dahl. Erickson, Fegg, House-Godot, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Holscher, Hershin, Luce, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty, Pittman, Pyle, Reichman, Steffen, Straub, Sullentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn,
As every senator had the opportunity to vote, the senator from Finney, Senator Dahl.
Thank you, Mr. Vice President. I would change my pass to an aye.
Duly noted. Are there any other senators wish to vote? Does any senator wish to explain their vote? Senator from Alley, Senator from Cali, Senator Alley.
Thank you, Mr. Vice President. Yes to pass on Von Aiken.
Yes, the senator from Sedgwick, Senator House-Godot.
Thank you, Mr. Vice President. I vote on confirmation on all of the individuals that are listed here for us to confirm today, especially on Nathan Springs and Alicia Sanchez for the Human Rights Commission, particularly because in the Federal and State Affairs Senate Committee confirming them, there was a question asked by the good Senator Reichman from Meade asking them their political affiliation, and each of them are registered unaffiliated, and Alicia Sanchez went on to say, I think the question was asked, how long? And For Nathan Springs, it had been 6 years, and for Alicia Keys, she'd always been unaffiliated. And so I think that will serve, they will serve us well in the position with the Human Rights Commission. So again, I vote aye, and I just wanted to share with the body. Thank you, Mr. Vice President.
Yes, the senator from Johnson County, the minority leader, Sykes.
Thank you, Mr. Vice President. Can I get a preliminary count on Von Aiken?
Yes, right now it's 19 to 19. Are there any other explanations of votes? Yes, the senator from Miami, Senator Baumgartner.
Thank you very much, Mr. Vice President. Oftentimes when we have appointments, it's just a name, but we do ask that the committees vet these individually, that they take into consideration what's in the application, but they also do background research themselves, and in that vetting process, they ask those questions, questions that come up when it's just not very clear in that application. My vote is of no for the appointment of Von Aiken is demonstrating my concern for how important this role is to serve on the CAPERS Board of Trustees. The term is trustee. And when we consider that 1 out of 10 Kansans is tied to CAPERS, it's our public employees. That includes our law enforcement. And when you look at the work history and lack of documentation that was shared by this employee to clarify why she possibly would have recommended a reduction in force for law enforcement for the community that she served in prior years. CAPERS has had a mixed history, bad investments, bad players. The legislature, as well as the executive branch, has played a role in underfunding CAPERS. We've been through a pandemic, but one of the things that we know that's even worse than a pandemic is if the fiduciary responsibility of those CAPERS trustees was to fail. The worst thing that could happen to our CAPERS retirees and those beneficiaries is if the CAPERS system were to fail. I cannot in good conscience, knowing the answers that this appointee was unable to provide the committee, support this recommendation. Thank you, Mr. Chair.
Are there other explanations of vote? The senator from Leavenworth, Senator Pittman.
Thank you, Mr. Chair. I was actually in the committee when those answers were given, and I'm not going to say the presentation was stellar, but I will say she had a fantastic explanation for her situation in California when they had to make a recommendation for a reduction in different services. It was right after the 2008 recession. The city had gone on an epic spending spree. You know how they do in California. And she sat there as the fiscally responsible voice to the city and tried to come up with solutions as they went slowly into bankruptcy due to the situation the city policymakers had put them in. And so it was easily defensible for that commentary. And I found her to be fiscally responsible when it came to answering the CAPERS question that she needed more information. She needed to work with the CAPERS board, the director, and understand the dynamics of the future balance when it came to that. One could look at that as ambiguous, but I look at it as sensible and perspective. We didn't nail her down on any particular question that would make her have an absolute, but any number of us could have done that up to this point. I do appreciate the good senator coming and explaining the no votes on this appointee, because I think she does deserve at least the explanation, since we didn't have the rigorous debate beforehand. So that is why I am voting yes on this. Thank you. I don't need my words spread across the journal.
Thank you. The Senator from Wyandotte, Senator Haley.
Thank you, Mr. Vice President. And regarding this particular nominee, in light of the discussion, both from the senator from Miami, Senator Baumgardner, and the senator from Leavenworth, Senator Pittman, I was not privy to the hearing, did not hear pro or con why this nominee should be affirmed. I do know that we get recommendations here to the Committee of the Whole on nominees all the time, and some of those that I have heard, I think of one who twice came before us as for the appellate court, did not pass muster through here. I felt that he should have. But one thing he did get here, for better or for worse, not once but twice, as all others have and should, was a clear up and down vote for where he stood. And earlier this week, Mr. Vice President, I noted that there was not a full count on a very crucial vote, and I was called upon, having passed, to cast my vote when I was just 50-50 on this. So that being the case, I note there are a couple who have not opined or weighed in specifically as to given all the information that has been forwarded by the committee to the Committee of the Whole on Kathleen Von Aiken. I'd like to certainly know where they would stand if asked by the Senate to do so or compelled to, and so I'd like to call and ask for the call of the Senate.
You have heard the call of the Senate. Do I see 5 hands? Seeing so, we have a call of the Senate on. We'll close. I stand corrected. The call of the Senate is out of order on appointments, on bills only. Back to explanations of vote. The Senator from Barton, Senator Straub.
Thank you, Mr. Vice President. May I still change my vote? I would like to change my vote from yes to no on Senate Bill 238, and then I have an explanation of vote on Senate Bill 39. While Senate Bill 39 appears benign on the surface and is already part of current law, my concern is for this incremental infringement of freedom on the freedoms of our individual mom and pop cattle producers. This could, in the future, violate their ability to compete in a free market. And like I said, as this may appear innocent on the surface, this could potentially harm the very people that feed the rest of the world. So if we're going to put these kinds of requirements, and this is not a requirement in this bill, but if we're going to support these type of things, I don't want them to become mandated in the future. And if we're so worried about what is in our beef, then we need to be concerned about what kind of imports we're bringing into our country and how we label those products. So I would just encourage the body to keep those concerns in mind. Thank you.
You wish your words spread across the journal? Yes, duly noted. Are there any other explanations of votes? Seeing none, does any senator wish to change their votes? Seeing none, clerk will close the roll and tally the vote. 40 having voted in favor and 0 against Senate Bill 47, Senate Bill 60, Senate Bill 170, Mary Berry on confirmation, Alicia Sanchez on confirmation, Nathan Spriggs on confirmation, 36 having voted in favor and 4 against on Senate Bill 238, and 35 having voted in favor and 5 opposed to Senate Bill 39. These measures having received the required majority are hereby declared passed and confirmed. 19 voting in favor and 19 voting against the measures not having received the required majority are hereby not confirmed for the confirmation of Von Aiken. We will now stand at ease.
Chair recognizes the leader from Cali, Senator Alley.
Thank you, Mr. President. I move the Senate resolve itself into committee of whole for the consideration of bills on the calendar under the heading of general orders.
You've heard the motion. All those in favor say aye. Opposed, no. Chair will preside over the committee of the whole. Having resolved ourselves into the committee of the whole, please turn your attention to SCR 1611. Chair recognizes Senator from Cali, Senator Alley.
Thank you, Mr. President. Would it be possible to have the reader read?
And actually, I'll have you adopt the committee report first.
Thank you. I move to adopt the committee report.
You've heard the motion. All those in favor say aye. Opposed, no. Report's adopted. Back to 1611. Reader will please read.
Senate Concurrent Resolution Number 1611. A concurrent resolution making application to the Congress of the United States to call a convention for the purpose of proposing amendments to the Constitution of the United States that impose limits on the federal government. Whereas the founders of our Constitution, empowered by state legislators to be guardians of liberty against future abuses of power by the federal government, and whereas the federal government has created a crushing national debt through improper and imprudent spending, and whereas the federal government has invaded the legitimate roles of the states through the manipulative process of federal mandates, most of which are unfunded to a great extent, and whereas the federal government has ceased to live under a proper interpretation of the Constitution of the United States, and whereas Article 5 of the Constitution of the United States empowers the legislature of the state of Kansas to apply to Congress for a convention of the states to propose amendments to the Constitution of the United States, and whereas it is the solemn duty of the states to protect the liberty of our people, particularly for generations to come, by proposing amendments to the Constitution of the United States through a convention of the states under Article 5, for the purpose of restraining these and related abuses of powers. Now, therefore, be it resolved by the Senate of the State of Kansas, the House of Representatives concurring therein, the Legislature of the State of Kansas hereby applies to Congress under the provisions of Article 5 of the Constitution of the United States for the calling of the Convention of the States, limited to proposing amendments to the Constitution of the United States that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. And be it further resolved, this application constitutes a continuing application in accordance with Article 5 of the Constitution of the United States until 2 years from the date of this resolution is adopted, or the date Congress calls a convention of the states for the purpose of proposing amendments to the Constitution of the United States, whichever occurs first. And be it further resolved that all concurrent resolutions making application to the Congress of the United States to call a convention of the states for the purpose of proposing amendments to the Constitution of the United States that have been previously adopted by the legislature are hereby rescinded on and after such date that occurs 2 years from the date of this concurrent resolution is adopted, unless Congress calls a convention of the states for the purpose of proposing amendments to the Constitution of the United States prior to such rescission date. And be it further resolved that the Secretary of State shall send an enrolled copy of this resolution to the President and the Secretary of the United States Senate and the Speaker and the Clerk of the United States House of Representatives, to the members of the Kansas congressional delegation, and to the presiding officers of each of the legislative chambers in the several states.
Senator from Cali, Senator Alley.
Thank you, and thank you to the reader for doing that. SCR 1611, as amended, serves the Kansas application to Congress under the provisions of Article 5 of the Constitution. And there are specific purpose for that, which we're going to talk about. The convention would be limited to proposing amendments to the U.S. Constitution for these three things. One, that impose physical restraints on the federal government. Two, limiting the power and jurisdiction of the federal government. And three, limiting the terms of office for members of Congress. As you heard on the reading of this, the resolution is a continuing application to Congress for the Convention of States until 2/3 of the state legislatures have adopted or applied to Congress on the same subject. So as we see, this is a process that may take some time. How did we get to that process? What is the process? Citizens asked the state legislators to sponsor and support a resolution for the Convention of States. A state legislator will sponsor the resolution and file it in his or her state legislature. The resolution passes out of the committee and floor votes in both chambers of the state legislature. This is not the final process that we're doing today, is not the final step in this application. When 34 states pass the resolution, the state legislatures choose delegates to represent them at the convention. States may have sent as many delegates as they choose, but each state will only get one vote. The state delegations propose, debate, and vote on the amendments limiting to the language of the resolution. Proposed amendments outside of the agenda would be out of order. Proposed amendments passed by a majority of the delegations are sent to the states for ratification. And the proposed amendment only becomes valid if ratified by 38 states. It only takes 13 states to stop a bad amendment from being ratified. Again, this is the start of a process, not the end of the process. So with that, I will stand for questions.
Questions for the Senator from Cali. Senator Hildebrand. Senator from Cherokee.
Thank you, Mr. President. Today is the day of the geographically challenged in the chamber. We have have had an issue with counties, it seems. My colleagues, I apologize up front. Normally, I do not talk very long. I usually don't have a whole lot to say when I get up and talk. I just get up, talk, and sit down. I hope you will bear with me because this is not going to be that time. First, I want to walk you through what we're getting ready to do today. There is a push. I'm going to read a little bit from a article that just came out from the Convention of States and Mark Meckler. And the reason why I'm doing this, I want to kind of use this to explain where we're going today. In it, it is calling on you and me to violate our state constitution. In fact, he says it's our duty to violate our state constitution because it is our duty to rein in the federal government. But it is not our duty to honor our oath of office by honoring our Kansas state constitution. Later, we're going to have a vote. After we debate this, we're going to have a vote. Currently, our Kansas Constitution requires, dictates, mandates that this body cannot pass an article or a resolution calling for a constitutional convention under Article 5 with less than 2/3 of its members, which is 27. After we debate and take this vote, we're not going to have 27. We're not going to have 28. We're going to have closer to 23, 24, somewhere around that mark, maybe a little bit higher, but we will not be over 27. We will be over 21. What's going to happen at that point is we're going to have a ruling from the chair declaring 21 as passed, passing this body, bypassing our Kansas state constitution. In this letter or article, they're promoting this process because they want to take it to federal court. They want to take it to federal court. So let's think about this for just 1 second. I've had many talks with members from the Convention of States supporters, and I'm going to tell you that those are some of the most patriotic, faithful people in the state of Kansas. I respect almost every single COS supporter. The grassroots people, I have the utmost respect for. Those people came to your district, many of yours, knocked on doors for you and helped you campaign. They get it. They understand what's going on. They also get, just like us in this body, that there's a problem with our federal government. Our federal government's out of control. It's a disaster. There might be a handful of people in this body that will disagree. I would be surprised if it's more than a handful. But our federal government is in a crisis. What we disagree on is how do we fix it? How do we fix this out-of-control government, federal government, that is ignoring, for all intents and purposes, our federal U.S. Constitution? It's not just one branch of government, in my opinion, and this is strictly my opinion, that is violating our U.S. Constitution. All three branches share the same burden. In fact, I will even venture to say that the 50 states are the enablers of the U.S. government violating the Constitution. So this organization, that their whole goal and their whole mission, even they testified in Fed and State, the same individual that wrote this article, the federal courts are out of control. They have made rulings that have given loopholes to violate our U.S. Constitution. I want you to listen again. The federal U.S. Supreme Court is out of control, has made rulings that have given loopholes for our U.S. federal government to violate our U.S. Constitution. That same U.S. federal Supreme Court, that they want us to violate our Kansas state constitution to go to so we can have a loophole to get around our state constitution. So we can violate our state constitution to fix the federal court that keeps providing loopholes for violating the U.S. Constitution. Makes no sense to me. The other part, he makes a reference. This is a quote. Federal power granted to the Kansas legislature by the federal Constitution, which cannot be constrained by the people of Kansas through the text of their state constitution. When you first read it, it just seems, kind of vague, all right, it's just a statement. But I want this body to understand something else that this organization says. Again, I'm going to read this quote. Federal power granted to the Kansas legislature by the federal Constitution, which cannot be constrained by the people of Kansas through the text of their Constitution. They will tell you that we are fearful of a constitutional convention because we are fearful of a runaway convention. Addressing that for just a minute. I am looking at my MacBook here. I prefer my MacBook. I like my MacBook. Sometimes I don't like the way it operates. I make changes to my MacBook. The state gives us a Dell or a Nova or something. I really don't prefer my Dell or Nova. I don't fear it. I just don't want to use it. I'd rather use this because I know where I'm going with this and I know where I'm going with that, and I prefer to go this way. But I digress just a little bit just to give you a example of just because you don't want something doesn't mean you fear it. And what they say is we fear a runaway convention. Their argument is the states control our delegates. The state controls our delegates. But they also argue federal power granted to the Kansas legislature by the federal Constitution, which cannot be constrained. So they are saying the federal government has control over those delegates, not the state. We cannot constrain our delegates because it is not in the federal Constitution. So with that, using that process that they want us to go to the federal court, federal Supreme Court, make a ruling so we have a loophole to violate our Kansas state constitution, which, by the way, each and every one of us took an oath of office. I believe some of you guys might have already recycled these. So in case you guys had forgotten, this is what we all took. I do solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of the State of Kansas, and faithfully discharge the duties of Senator. So help me God. But they want us to violate that oath. They want us to violate the oath. And if we don't, we're fearful. We're afraid. We're afraid of doing our job of reining in the federal government. They want this to happen, and they want to have a lawsuit to go to the federal Supreme Court. A lawsuit. They want an individual, a Kansan, to sue the state of Kansas to prove that the federal government, so the federal Supreme Court, can give us a loophole to violate the Kansas state constitution. Which brings up a question for the carrier of the bill, or the resolution. Do we know what the fiscal note will be on that lawsuit?
Senator from Cali, Senator Alley.
Thank you, Mr. Chairman. Thank you, Mr. President. Could I have you repeat that question again, please?
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. Chairman. The goal of the Convention of States, as outlined in this article by Mark Meckler, is to get this into court. You file, so an individual in the state of Kansas can file a lawsuit against the state of Kansas to get it into the Kansas state, or not the Kansas, I apologize, the federal Supreme Court, to get the federal Supreme Court to issue a ruling, give us a loophole, an opinion, I apologize, opinion. Courts don't make rules, they issue opinions. Issued an opinion that the state of Kansas has a loophole around their state constitution. So I am asking, what is that fiscal note for that lawsuit?
Senator from Cali, Senator Alley.
If there was a lawsuit, we don't know when that would be, so it'd be kind of difficult for me to ask that question and give you an answer to that question. But we do know that this question that you've asked has not been, well, let me ask you this question before I answer that. When would that lawsuit be able to be filed?
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. The Attorney General can issue a fiscal note. We debated a bill not too long ago that had a fiscal note from the Attorney General that listed out the cost of what it would be to defend that bill. And I believe it was the sports, Fairness in Sports Bill, and I apologize, I could be wrong, that that was in there. And I would assume, and I apologize for assuming, that he would be able to do that and provide that for this bill as well.
Senator from Cali, Senator Alley.
Thank you, Mr. Chairman. The issue that I have is, when would that be able to file the lawsuit? Is it when we make application or when the 34 states go to the convention?
Senator from Cherokee.
Thank you, Mr. President. Mr. President, I do not intend to be that individual that's going to file the lawsuit. I have no idea when the COS has in mind for filing a lawsuit, but they do. We know it's going to happen if this bill does not pass out with 21 votes. So we do know that there will be a lawsuit filed in a district court. And I apologize if I get the steps wrong. I'm not an attorney. You're going to go into district court. There'll be an appeal. You'll go to the appellate court, and then it will go to the Supreme Court. How long that process takes, I am not sure. I don't know that that's relevant. The relevant part to my question, however, is, do we have a fiscal note on that process?
The answer to that question is we do not.
Thank you. Thank you. So, colleagues, after this debate happens, you're going to vote on this. And as I previously mentioned, we are not going to get to 27 votes. We more than likely will have 21. It is going to be ruled passed with at least 21 votes. There will be a challenge of the ruling of the chair. You will have another opportunity to vote. At that opportunity, you will be voting whether or not to sustain the ruling of the chair. A yes vote would mean that you agree with the chair that 21 votes is all we need to pass this bill, this resolution. And the caveat that you believe we have a right as a state legislature to ignore our oath of office and to violate the Kansas Constitution. A vote no is a vote not to sustain the ruling of the chair, and that you believe that this state legislature is bound to its oath of office to uphold our state constitution. The reason why I bring this up is I know we have a lot of new senators in this chamber. This process is going to be very different than anything you've ever seen. A lot different probably than most of us have even seen that have been here for a little while. I think it's important that you understand the process so you're not caught off guard and you have some time to think about what your votes actually mean before you have to take them. When I was new, I hated not knowing what was going on and having to take a vote. And this is a serious vote. You have two serious issues that you're going to vote on today. First is the Convention of States. Many of you, many of my colleagues and friends support the Convention of States. And I still respect you. I still appreciate you, and I still appreciate your opinion, because your opinion is important. We just disagree on the method to fix the problem. And there's nothing wrong with that. Nothing wrong with that at all. And I hope when we leave here today, those of us that do not support the Convention of States, and those of us, or those of you that do, and still respect each other and say, hey, I might not agree, but you know what? I appreciated your input. I appreciated your perspective. I appreciated the points that you made or the points that you didn't make. But we still have to come back tomorrow and the next day, and as colleagues, work together for the betterment of the state of Kansas. The next hardest part will probably be the hardest vote you'll have to take. I have to tell you, this is something that I've struggled with. I respect each and every one of you in this chamber. I respect each and every one that is in leadership. Knowing that today, because unlike what you're going to read from the Convention of States, I do love our Constitution, our state and federal Constitution. I think it's important that we stand up for our Constitution. And one of the hardest things I'm going to have to do after we debate this bill is I'm going to have to challenge the ruling of the chair and put you guys on a tough vote. I don't want to do that. I would prefer not to do that. But because I feel so strongly about protecting and defending our Constitution, our state Constitution, and U.S. Constitution, I have no choice. If I did, I would take it. For those of you that puts you in a tough situation, I apologize. I promise you, I would rather not do it. But I have no choice. The reason why you might wonder, why is Senator Hildebrand talking so long and so passionate about this subject? I just want to give you a little bit of history on this. I talked earlier about my respect for most every member of the Convention of States. The grassroots people, man, they're patriots. They're like us. They're sick and tired of our federal government doing what they're doing. It's frustrating. It is absolutely frustrating. They feel helpless, just like we do. We're helpless against this behemoth government that has no regard for the people. We are a government of we the people. And we the people, and I'm talking as a citizen of Kansas and a citizen of the United States, feel powerless. Yeah, we get to go to the voting booth and elect who we have our choice to elect. So many times we go to the voting booth and it's the lesser of two evils, so that's who I'm voting for. That's what we have. I don't like it. I think there's a better way. I think there's a way to change it. But in my time, last time I had an opportunity to vote on this same bill, I voted no. Same reasons I have today. Except I'm a little more passionate today just because we're being asked to violate our oath of office and to disregard the Kansas State Constitution. Not long after I made that vote, and by the way, for those of you that don't track your name on the internet, I encourage you to do it. I got a notice that my name was being used And my name's kind of hard to spell, apparently. So I have mine tracking several different variations of my name. And the individual that wrote this article misspelled my name. For that individual, my name is spelled Hildebrand, because I'm going to be written about as soon as this is over. I'm probably being written about now, which is fine. I can have a discussion with people about why I believe the way I believe and not call people names and not be dishonest about that individual. But this individual went on I don't know what it was, some talk show, and told talk show host let me back up. The talk show host asked, why did Republicans vote with Democrats on this vote? His response was, I don't know. I sat down in every Republican's office and talked to them, and they could not give me a reason why they were voting against our Convention of States. Sounds pretty reasonable, right? Except for one problem. That individual never talked to me, never had a conversation with me until last year. I ran into him at an event. We were eating. We had a discussion. It was a cordial discussion. But I explained to him and asked him, was this the first time that we've ever had a conversation? And they said yes. I said, wow, that's interesting. I referred back to that article or that video. He couldn't remember. There was also an article that was written by this gentleman, called me a traitor. Richard Hildebrand is a traitor to the United States and to the state of Kansas. That's what I was called in this article. I was also called, whatever this means, an unconstitutionalist. I hate the Constitution because I do not support the second part of Article 5, which is not 100% accurate. It's not that I do not support it. I just do not want this opportunity to happen at this current time. I do believe that there is a purpose and that our forefathers, founding fathers, put that in there for a reason, a very good reason. Not for today, though. So you see, I have to use this opportunity because I have someone, a fan, I'll call him my fan, is going to write an article and going to go on Facebook and is going to say things that I have said or I believe that are not true. So I've got to give this opportunity so when those things are posted, I can show this video and say this is actually what happened. This is what I actually believe. So again, I apologize for taking so long. I touched on our oath of office. The biggest thing about this lawsuit that's coming is there was an Attorney General's opinion. I shared this with you the other day. I don't think I gave it as a handout because it's like 30 pages or 20 pages or something, so I didn't want to overburden the Sergeant of Arms because I had him hand out a bunch, and thank you for the work that you do. I appreciate that. But in the Attorney General's opinion, and I don't make it a habit of reading an Attorney General's opinion and saying, man, I just disagree with that. But in this case, I had to. In his opinion, he mentions several places. Supermajority requirement is merely precatory, or in other words, an expression by the people of Kansas of their desire that the legislature muster a 2/3 vote in each house to ratify federal constitutional amendments or apply for Congress to call a convention for proposing federal constitutional amendments. He goes on to state that the federal U.S. Constitution under Article 5 negates that. He points out that it's the legislature's responsibility for deciding how to apply. I agree. I agree 100%. Where I think, or where I disagree, is it wasn't the people of Kansas that's dictating to us, the legislative body, how to call this Article 5 convention. It was this body back in 1974, a legislative referred constitutional amendment. Each and every one, and the good senator from Cali, our assistant majority leader, defined how and took you through the steps of how this resolution, where we're at today, how it went through the process. In 1974, it went through the same process. Now the COS is going to try to tell you, it's in this article, that it was snuck in here, that there was no debate. Well, okay, maybe. I find that hard to believe that it wasn't in a bill where people could read it, bill form. You know, I would argue there's bills that come through right now that probably snuck through that people don't pick up on. That's part of the process. That's the legislative process. There are different types of state constitutional amendment procedures. Our good neighbors to the east, Missouri, they can do what's called a referendum. Their bar is a lot lower than ours. Their citizens can apply with enough signatures for an amendment to their state constitution. If we were a referendum type state, I would agree 100% with what our Attorney General issued in his opinion. However, we are not. We are a legislatively referred constitutional amendment state, which means the legislature in 1974 worked that amendment, brought it to this floor, voted on it, that is how the legislature, the Kansas legislature, wants to be able to call an Article 5 convention. Then they send it to the state for the citizens, for them to vote on it. They ratified it. The will of the people of the state of Kansas, by over 68%, agreed with the state legislature that the bar for going and applying for an Article 5 convention should be higher than 21, and it should be 2/3. Simple majority over in the House as well, 63 to 84. So there's the problem, I feel, with the opinion of the AG. As far as our state constitution conflicting with the U.S. Constitution under Article 5, I handed these out as well. The first thing I'm going to read to you is going to be Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. That is our first way for an amendment to our United States Constitution, is by the Congress. Whenever 2/3 of both houses of Congress propose them or deem it necessary. Or, this is the second part, and this is the part we are debating today, and this is where I would like for you to pay attention to the words, on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. And provide other stuff that's irrelevant. So I want you to, again, concentrate on what I just read. Now I'm going to read Article 2, subsection 13 of the Kansas State Constitution. A majority of the members then elected or appointed and qualified of each house, voting in the affirmative, shall be necessary to pass any bill. 2/3 of the members then elected or appointed and qualified in each house, voting in the affirmative, shall be necessary to ratify any amendment to the Constitution of the United States, or to make an application for Congress to call a convention for proposing amendments to the Constitution of the United States. Friends and colleagues, what part of Article 2, subsection 13, violates Article 5? There is nowhere in Article 5 that dictates to the state legislature on how to call or how to petition for an Article 5 convention. It is silent. There is one thing that it does say, and this is the key. On the application of the legislatures, the several states. The legislatures. Friends and colleagues, this is where the Attorney General made his opinion. This is where the higher-ups of the Convention of States say Article 2, subsection 13 is in violation of the U.S. Constitution, because the legislature passed this in 1974, was ratified by the citizens of Kansas. Because we let it ratify, or they let it be ratified by the state of Kansas, letting the will of the people have some input on changing our U.S. and state constitutions, that violates the U.S. Constitution under Article 5. We, the people, have no say according to what the Convention of States is arguing. We, the people, over 68% of Kansans at that time, have no say, because the legislature, it's their authority to decide how to send this, what the requirements are. The legislature decided to put this to the vote of the people. This is what they wanted. This is what they decided. 2/3. The people didn't decide. The people ratified and agreed. But we, the people, apparently don't matter. Walked you through the first part of the process. I'm going to go through why now I do not support the first vote that we're going to take, which is the Convention of States, Article 5. One of the things that you will be told, or you will hear, is that we have no other option. What are our options? Keep doing the same thing you're doing, you're always going to get what you always got. I agree, 100%. Spot on. We agree on that. Again, we don't agree on the process to fix it. Under Article 5, there's two ways to pass an amendment. So far, the first part successfully passed 27. The second half is 0. So, we believe, or we're expected to believe, that if we pass a convention of states, we are going to we're going to be groundbreakers. We're going to be history makers, which is true because we're getting ready to violate our state constitution, so we are going to be history makers. But we're also going to be history makers for passing the First Amendment under the second part of Article 5 of our U.S. Constitution. I apologize if my math is bad, but I think 232 years our state has had this new constitution. We did not get here overnight. We did not fix, or we did not have this problem the way it is now overnight. It took us 233 years to get to where we're at. One of the things that, when I'm talking with people, especially that are they're wanting to know my beliefs or my thoughts on the Convention of States, and most of your grassroots people, man, they want to listen to you. They might not agree with you when you talk, but boy, they listen to what you have to say. They give you their input. They don't call you names like some people in the Convention of States, but at least they sit there and listen to you and have a conversation, and it's productive. It is. And sometimes they give me things, I go, maybe I'll do some more research on this. But in the end, they're receptive and they understand, but they come back, they always come back with, well, we've got to do something. What else can we do? What are our options? And when I explain, hey, we're 232 years under this current document. If you were to go home and you were walking up to your house and your roof is split, you see your roof is split, first thing you do is you go call a roofer or someone that does construction. They come out and they look at your house and they look at your hole in your roof and say, yeah, you have a hole in your roof. I can fix it. Won't take very long. It'll be a real quick fix. But here's the problem. Your foundation's broken. I can fix that, but eventually, very soon, you're going to come home with that hole in your roof again. I would suggest you fix the foundation first. You have an option. Fixing your roof is immediate. Path of least resistance, cheaper on your pocketbook. You just go do it and it's done. But in no time at all, it's going to be the same until you fix your foundation. Why is our foundation broken? I'm going to go out on a limb, but until the hearts of people in our nation change, our foundation is broken and won't be fixed. We have to fix that first. Once you fix that, then you have to do what these patriots with the Convention of States, grassroots people are doing. Go and talk to your legislature. Go and talk to your local government people. Be involved. Hold them accountable. Hold us accountable for what we do. Hold us accountable for each and every vote we make. Each and every time I've had that conversation, that will take too long. We need to get this fixed right away. We have to do it today. We have to do something. I agree we have to do something. We have to fix our foundation. Until then, it doesn't matter what we do at the top. It's going to be broken eventually, back to the same way. I haven't convinced anybody yet that that's the way to go, so maybe I am wrong, but that's the way I believe. Hopefully one day we can make a difference and get people's hearts changed, get our foundation fixed, get we the people back involved in what's happening in our country. Some of the other issues that I have with an Article 5 currently, and we'll just go over what it's actually in this resolution. Number one, fiscal restraints on the federal government. Should be easy, right? Balance your budget. Quit printing money. Don't spend more money than you have. Simple fix, right? One of the reasons why the federal government is so large is because we, the 50 states, are a bunch of enablers. Us. I'm just as guilty as everybody else. We're enablers. We are addicted to that federal dollar. We have to have that federal dollar. Boy, let's get that federal dollar so we can spend more money. I did a little bit of research, just out of curiosity, because sometimes I do get curious, but everybody, we just did a budget not too long ago. Our SGF spending was a little over $8 billion. That was all money that we raised in taxes on our Kansans. $8 billion is a lot of money to me. Would you believe it if I told you that on top of that $8 billion we spent of Kansas's money, we spent $13 billion federal dollars? $13 billion. With that $13 billion, there's always strings attached. We had an issue, and we always have issues. There's lots of issues. I could give numerous issues, but this one's more recent. We had an issue in public health and welfare not too long ago. Actually, we had an amendment on the floor that addressed this as well. There were a couple of nursing homes, just a couple. It's just not a big number. And before I get on that, our nursing homes, for the most part, during this period, did a wonderful job. They did everything they could to keep their citizens and their facilities safe with little or no resources. They did everything they could. Just as recently as a week, 2 weeks ago, there was still a nursing home in their county that had not had a COVID case in over a month. In the county, let alone the facility. They still would not let their residents have a one-on-one visit with their family members and loved ones. So when we had the hearing on a bill that addressed this issue, we heard from everybody that, oh, don't work that bill. Please don't work that bill. Please don't pass that bill. If you do, we're going to lose our federal money. We're going to lose our federal funding. We've got to have that federal funding. We've got to have that federal money. A couple of the members on the committee were quick to point out, what about personal freedom, personal rights? Well, we sympathize with that. We have to have that federal dollar. That federal dollar, we cannot operate without that federal dollar. Some of our other members talked. A couple of them said, well, that's what we get when we take federal dollars. We have those strings attached. We have to be more careful as a state if we're going to take fiscal restraints serious and demanding fiscal restraints on our federal government. We cannot be enablers of an out-of-control spending government. For that fact, we can't be out-of-control spenders. $13 billion in the state of Kansas isn't big money. And it's hard once you are used to getting $13 billion from the federal government to say no. But if we expect our federal government to have fiscal restraints as a state, and we expect that, and we demand that, and we are going to send delegates to a convention to demand that, don't you think it's a bit hypocritical when we're the enablers? That we're allowing that to happen? What are we going to do when we go and demand that and they say, okay, we're going to stop sending you money? It's fiscal restraint. What's the state going to do? We're going to lose $13 billion. What will we do? Some of us will be okay. We can figure it out. Most of the state would know what to do. So are we really going to go and demand fiscal restraint when we are the enabler? I argue that we won't. The second item on this resolution, term limits. Term limits. How long can we serve in this body? What are our term limits? Every 4 years? 8? 12? 16? The only term limits imposed on us are the will of the people. The will of the people. But we think, in our arrogance, just because we don't abide by term limits and we don't have term limits, We should dictate to the federal government because we're going to demand that they're out of control. And the way to fix it is term limits on them, not us. Even though we're the enablers, we can serve as long as we want. But the federal government, because they're out of control, unlike us, they need to be controlled with term limits. I would argue, I'm not really opposed to term limits. But we should start here. If we're going to demand someone else have term limits, we should have them first. Fiscal or size of government. We are going to control the size of the federal government. We can't even control the size of our state government. How are we going to make the federal government control the size of the federal government? What amendment are we going to put up there to say, you're in control, you're out of control? What are we going to do? What are we going to ask our delegates to do when they go to a convention to control the federal government? I don't know. Start getting rid of some agencies? Department of Ed, Department of, I don't know, EPA. Don't get me wrong, I believe we could cut back on that. We also could cut back here. Why don't we start doing it here first? Let's control our size of government first before we go and try to tell somebody else how to control their size of government. One of the things that the Convention of States will tell you on a runaway convention is, I think you've heard it, I think the carrier of the resolution touched on it, that it takes 38 states to ratify an amendment. Only takes 13 not to ratify an amendment. You're not going to get a bad amendment because you're not going to get 38 states to ratify it. So let's take that argument. This is the only solution that we have. This is our best solution. Let's get it done. Let's get it done now. We call a convention. They go. They adopt term limits. They adopt fiscal restraints. They say, you've got to cut out all of your agencies. Let's get rid of the IRS, be number one. Term limits, size of government, and fiscal restraints. Can't send us any more money. So they go. Really great amendments. I agree with them. It is very hard to get 38 states to ratify an amendment. A bad amendment especially, but even an amendment. So I ask you, for a good amendment, how many states, name those 38 states? I'm a conservative, so I'm going to use my point of view. Nothing against people without my beliefs. I believe, I don't know, somebody might say I'm a bleeding heart liberal. I might be, but I'm going to call myself a conservative for argument's sake today. I want a conservative amendment. I don't want an amendment that is not conservative. Oh, I can't name you 38 states that are going to ratify a conservative amendment that I would like. I can't get there. I tried. I sat down one day when I kept hearing this argument, like, let me see if I can get there. For some reason, I like to count. It's some oddity that I have. But anyway, so I'm counting, and I can't even get close. So let's say we are successful. We pass this Convention of States. We've given our strict orders to our delegates because we know We have the power, not the federal government, unless you listen to what was written in that article. They're going to adhere to what we tell them. They go, they come out of the convention with these amendments. How are we going to get 38 states to ratify those amendments? And I don't remember, I do enjoy history, and I should have looked it up a little bit, and I can't remember, there was an amendment that was, it was a lot of years. And I want to say it was over 90 years or something, and I could be wrong, so please don't quote me on that number. Somebody maybe can look it up and correct me later of what that is, but what amendment I'm talking about. That it took that long for that amendment to pass. And if memory serves me right, it was a good amendment. I'm thinking, wonder why it took so long for that amendment to pass. But it did. So we've got to fix this. We've got to fix it now. We're going to go in. We're going to get some good amendments. They're going to come out. And we're going to get them ratified with 38, just like that. Not going to happen. Not in today's world. It's going to take a long time for those amendments to get ratified, even if they are what we want. So why do we not go back, since it's going to take a long time, and fix our foundation first? Concentrate on our foundation. The Articles of Confederation. Do my colleagues remember or know what the Articles of Confederation were? If you don't know what the Articles of Confederation were, that was our original Constitution of the 13 states. Very, very powerful for the states. The states had all the control. They had all of the power. It truly was a state power first Constitution. I really don't think they even called it a Constitution, or I think it was a friendly agreement with the states, 13 states or something like that. There was a problem with the Articles of Confederation. The states had too much power. We just come off of wrong time period. Revolutionary War was very, very costly. Under the Articles of Confederation, each state could contribute what they wanted. Instead of millions and millions and millions of dollars to pay off the debt, I believe the federal government one time just received a little over $1 million or almost $2 million. They couldn't pay off their debt. The federal government had no way to tax. It was a unicameral form of government. It had one Congress. That was it. Federal government could print money. And printed money they did. Inflation kicked up. There's an incident that happened called Shays' Rebellion. Not sure how many people know or understand what Shays' Rebellion was. It was a farmer, last name is Shay, that was, for his time, I don't know, he was a farmer. Most of the people in Congress at the time were attorneys or rich people that had lots of plantations. Shay and his rebels, they kept getting taxed, and taxed, and taxed. Their property was getting repossessed by the state or commandeered by the state, however you want to call it. So they rebelled. And I forget the state they were in. But that state had a hard time of squashing that rebellion. There was no strong military force at that time, federal or state. So they did have the militia, the state militia and private militia. So they had to hire those to squash the rebellion. And they did. That was the catalyst of changing the Articles of Confederation. There were 13 states at the time. So the 13 states knew that there was an issue, that they had to do something. So there were a couple of states that met in Annapolis, called the Annapolis Convention. All states were invited. 5 states showed up. During the Annapolis Convention, that's where the Constitutional Convention was born. So the 5 states penciled out a plan to have a Constitutional Convention. Under the Articles of Confederation, it took 13 states out of 13 to ratify any amendment to the Articles of Confederation. After Annapolis, you go to Philadelphia, Liberty Hall. The Constitutional Convention is called. The delegates, contrary to what some people will say, were given strict orders. Amend only the Articles of Confederation. Amend only the Articles of Confederation. So once everybody got to Liberty Hall, it took a while. They actually convened when they had 7 states. They started the Constitutional Convention with 7 states, 7 out of 13. 7 was the quorum that they needed. 7 states voted on a president of that convention, which was George Washington, who oversaw the convention. They voted on the rules, similar to what we do here. One of the rules that they passed was everything was to be done in secrecy. You know, I think today, how would that happen? How would it be secret today? Because of all the press, the social media, everything that you have. One of the things you have to remember is Ben Franklin was in that group, or involved. At that time, Ben Franklin, I think, owned 8 out of 15 of the papers. So he was okay with it. He was there. So they go into secret meetings with 7 states. They eventually get to 12 states. They never get to 13. So they have a problem in there. Under the Articles of Confederation, it takes 13 states to ratify an amendment. They only have 12. Cannot get 13. What do we do? Well, James Madison has, while they were waiting for a quorum, drafts what's called the Virginia Plan. The Virginia Plan was a large states constitution, similar. It was the blueprint of what we have today. That's what they started with back there. The discussion breaks out as, hey, we're just supposed to amend this. We're not supposed to do a new constitution. Well, it quickly evolved to, well, Articles of Confederation we just can't fix. So let's have our new constitution. So they start working on our new constitution, get it all drafted, work it out. A big battle between the large states, small states. Large states wanted more voting power. Small states said no. One state, one vote. Work some things out. they came to a compromise. We had the republic. First time in history, a constitutional republic. Unique to any government in the world. The Founding Fathers, with their original Constitution, had created the greatest nation on earth. As long as they could keep it. I believe that was a quote that Benjamin Franklin said when he was coming out. Someone asked him, what kind of government did you guys create? A republic, if we can keep it. So they still have a problem when they come out. They still need 13 states to ratify under the Articles of Confederation. Not under a new constitution. They can put in whatever they want. They don't need 13 states. So during that time in their convention, I'm sure a lot of well-spoken, a lot smarter and more intelligent people than myself were in the room conjuring up how they could get a new constitution passed. When that constitution comes out, they only need 9 states because they can't get 13. I say that because one of the things that you will hear is that there's no way for a runaway convention, there's no way to get a bad amendment because you need 38 states to ratify. That's true on an amendment. You have to have 38 states ratify. If, I'm not saying it would happen, I'm saying it can happen. New Constitution, like what happened at the Articles of Confederation, comes out, they're going to figure out how many states they need to ratify that and kick it out. Might not happen. I don't know. I'm a big believer. If you don't know history, you're doomed to repeat it. So you better know what happened in history. Many of you in this chamber have heard of the Federalist Papers. Federalist Papers were papers that were written in support of the new Constitution. Why did they need the Federalist Papers of this new Constitution? Because they only needed 9 states to ratify. Well, they had a problem still. They only had 5, I believe, that ratified quickly, so they needed to get to 9. So there was this big war of words that happened. You had the Federalists that were pro-Constitution, this new Constitution. They liked a stronger federal government. Alexander Hamilton, George Washington, John Jay, John Adams started penning letters that were printed in local newspapers and around promoting this new Constitution. They got a lot of press because remember, Benjamin Franklin, he was a Federalist. I bet, not a betting man, but I would assume, bad for me to assume again, that very few people have ever heard of the Anti-Federalist Papers. If you haven't, ask yourself why. Why have you not heard of the Anti-Federalist Papers? Anti-Federalist Papers were written primarily from Thomas Jefferson, James Monroe, Patrick Henry, and Samuel Adams. They did not want the new Constitution. They did not like the way it was written. Once the Constitution got ratified, these gentlemen did change after the Bill of Rights were passed. They feared what the government could do without those Bill of Rights, and they wrote about it extensively, called the Anti-Federalist Papers. But many people have never heard of them like the Federalist Papers because they didn't get much airtime or paper time back then. Why do I say that? Why do I bring that up? You get a new constitution that comes out of a convention, constitutional convention. Who's going to get the airtime? Who's going to get the airplay? Not going to be Donald Trump. He's banned from everything. It's going to be somebody else. Again, you know, cannot reiterate enough to my colleagues, my friends, people listening online, grassroots COS people. I appreciate you guys. I respect you guys. I hope what you are taking from this isn't condemnation, but is my perspective. It's my view. I should be entitled to my view and my reasons why I do not support something. I guarantee you, if you have a differing opinion than myself, I'm going to listen to it and we'll have a discussion. But I'm not going to walk away calling you a name and saying how bad you are because you don't believe like me. I wished you did. We'd get along a lot better, I think, but or maybe not, I don't know. So I'm going to circle back a little bit. Why are we changing? Or I'm not changing. Why are some willing to change or violate our Kansas State Constitution? What got us here? What got us to the point that someone felt the need that we needed to get this pushed through at all costs? And at all costs, we're going to violate our oath of office, violate our state constitution to get this passed. I would imagine it's because since 2013, every other year, almost every year, this same resolution has either been in this chamber or the opposite chamber across the hall without any success. So why 21? Well, the last time, 2018, oddly enough, it's the same SCR number, 1611. This Senate, this body, voted on this same exact bill, except for, I apologize, the language was a little bit different. We didn't have the amendment from the Senate, and it actually put the 2/3 requirement in there. It failed 22 to 16. And if we didn't have that state constitution, that passes. We don't have that state constitution, that passes, it goes to the House. The House can pass it with 63 because they did it the year before, 77. We have over 63 in the House, we have over 21 in the Senate, and we failed because of our state constitution has that 2/3 requirement in it. What do we do, or what do they do? Let's figure out a way to violate that state constitution. What should have happened, don't want to give them any ideas, but I'm going to. If it was me, and I didn't like what was in our Constitution, instead of going to the federal Supreme Court that I believe is a terrible Supreme Court, an activist Supreme Court that keeps giving loopholes to the federal government to violate the U.S. Constitution, I would not go to that same Supreme Court to issue an opinion to violate the Kansas Constitution through a loophole that federal U.S. Supreme Court just provided. There's a process to amend our Constitution. If the legislature wants to change that, pass a resolution, send it back the same way that it was passed in '74. That is the proper process. If you do not like what is in the Kansas State Constitution, at least try before you bring a bill up or push to have a bill brought up to this floor and ask senators to violate their state constitution. At least put an effort. If you're not willing to put an effort into doing it the right way, it's the easiest, quickest way. That takes too long. We've got to get it done now. Mr. Chairman, I appreciate the indulgence of my colleagues, my friends, and the good senator from Cali that is carrying this amendment or this resolution. I've taken up plenty of time, and I see there are other people standing that wish to speak on this. I will sit down and let others speak.
The chair recognizes, does the senator from Cali, Senator Alley, have a response?
Thank you, Mr. Vice President, but I didn't hear a question, so I'm not going to respond at this time.
The chairman then turns to the senator from Brown, Senator Pyle, for some remarks.
Thank you, Mr. Vice President. I'm going to start off by reading, this was in the Sunflower State Journal. It's an issue that's been percolating behind the scenes for a couple of years. It's been generally accepted that the legislature needs a supermajority to ask Congress to call a convention of states for proposing amendments to the U.S. Constitution. The two-thirds requirement, after all, is written into the state constitution. Senate President Ty Masterson is expected to put that to the test Wednesday when the Senate takes up a proposal asking Congress to call a convention of states to place limits on the federal government. Masterson on Tuesday told Senate Republicans that he plans to declare the resolution passed even if it gets a simple majority, but fails to make the two-thirds requirement established by the state constitution. The goal, Masterson said, is to resolve questions raised by a 2019 Attorney General's opinion, suggesting the constitutional provision is essentially an expression of the will of the people of Kansas and isn't binding, even though it's in the state constitution. You can read further if you want to. You can find the article. We are policymakers. We're here debating policy, normally, for the purpose and goal of sending it to the other body or to the governor, whatever. But according to what is being stated and what we heard in a Republican caucus yesterday, the goal is not that. Our policy question today is being muddied thoroughly, because we have a lot of other things that are circulating around in the water, stirring all this to make it muddied. Whether you support the COS or don't support the COS, you know, there's other questions that we have to deal with here. One of them, consider this. Yesterday we debated a bill about litigation and avoiding litigation, avoiding the costs of litigation. We were on it for hours. The chair of Judiciary debated and answered questions all around those questions, all around that issue. Today, here we go. One of the questions that we have to decide on this muddied issue now isn't about COS and passing it to the House. It's about there's litigation costs. That's the goal. How much is it going to cost the taxpayer? There's a lot of unknowns. We've already heard that. We don't have answers. We don't know when. We don't know how much. We don't know how long. It's muddied up. Now we're dealing with an issue of finance and litigation. What's the goal? Our goal ought to be, if you're for and in support of this, to get the necessary votes and pass this to the House. You know, maybe that's the tactic here. Maybe throwing out the litigation proposal is to maybe get enough people to vote 27 and get it to the House. I don't know. That's not a bad tactic, though. Maybe we ought to just all vote for it, send it over there, and what was said in caucuses isn't going anywhere. They'll sit on the calendar all year and next year and die there. So, you know, if you don't really want it, you could vote for it just to do that. I'm not going to advocate either way, but I'm just saying that's a tactic that could be employed. So that's a very clever tactic if that's what they're trying or what's going on. But anyway, that's one issue, to avoid the litigation costs. But the longer view, we have dealt with this in the past. You heard that from the senator from Cherokee. And we've had votes on this. The House has voted on it, the Senate's voted on it. There have been issues in the past. If we were sincerely trying to get a constitutional convention, we would have to deal with getting it through this chamber first right now. That should be the only issue right now, but it's not. It's muddied. So we have to deal with these issues. We all know we are a country and we have rule of law. We have a constitution at the federal level. We have our state constitution. We have a book in our desk, most of us, with the rules of this chamber. We have to follow them. We're a rule of law country. And yet, we are here today muddying up this issue as my understanding we're going to have a rule challenge, that we're going to have a determination made that this is going to pass with less than 27. Well, we aren't there yet, so we don't know that. That is the intent of this debate today. Then the intent is not to pass the COS. The intent is to get to a ruling, and I don't know, is that politics, grandstanding? You know, helping to get the issue talked about and printed in the paper, more people read about it. Is that part of this? Is that part of the politics of what's going on today? Is that part of what's muddy in the waters? Somebody's going to make a motion, so somebody's going to get their name in the paper because it's never been done before? Look around. The water's muddy. Kind of difficult to know, isn't it, what we're going to do? The goal is definitely not to just pass this and get it to the House. We've got other issues. Another thing that I think we all need to consider, I've heard a lot about our oath that we took to the Kansas Constitution. But we need to go a little further. What are the consequences of violating that oath? Maybe we should have the Secretary of Senate get us a list of what can happen to us if we violate our oath of office. There's a consequence. So we're stepping into those waters, making them even more muddy if we go this far as to let the chair rule that it passes. Got a journal this morning. Come in my office, usually have my assistant grab a journal and a calendar, and I glance over them. Like to have the House one too. But on today's journal, on page 1118, final action on bills and concurrent resolutions. On motion of Senator Alley, an emergency was declared by a 2/3 constitutional majority. I guess we don't need that anymore. We're going to do what we're going to do. I mean, when I saw constitutional majority, kind of jumped off the page at me. But again, the waters are being muddied. We're here to challenge that today. It's not about getting the COS pushed for a convention and having our state vote for a convention. It's about all these other issues that the water's been muddied up with. the reader read the resolution, state legislators, guardians of liberty, future abuses, going down under a proper interpretation of the Constitution, the purpose of restraining these and related abuses of power. If we're not going to abide by our own state constitution, which we swore an oath to, what are we? We aren't any better than the people we're trying to get a resolution so we can call a convention to try to fix the problem. I just made all these observations and I took notes. I told Senator Hillerman I didn't plan on saying anything. But as I sat here and listened, he makes great arguments. People can make great arguments on the other side. It is a very divisive issue. No matter how you vote, you are going to be challenged when you leave here. I know because I was here when we had the past vote. And those that will come up and respectfully ask you, you will be able to explain your vote and probably continue in a good relationship. But there will be some that will not understand. How dare you? But I hope you're able to tell them how muddy the water was today. Because this is about litigation costs and other things. It's about abuse of power. It's about your oath. It's about the consequences of violating your oath today. Like I said, maybe the tactic is to get to 27 and we won't have those problems. Maybe that's one of them. I think I'm going to stop. Time is limited. I'm not going to say, I know I could go on, but just some observations, something to consider as you look at the COS proposal before you. Is it really genuinely, do you want to vote to send this to the courts and burden the taxpayers? We all know that we have budget needs and we have issues, things that need to be funded. And so we're going to tie up those tax dollars that those people make and it put more of a burden on. I don't think that's the decision we want. So when we're faced with a real clear-cut concurrent resolution that says the goal is to get it past this chamber and get it to the House, you know, maybe the first thing this body should do is withdraw all of this and propose a constitutional amendment to the Kansas Constitution to change the 2/3 majority. That would be the first step, and do it in a proper fashion. Thank you, Mr. Chairman.
Senator from Cali, Senator Alley, care to respond?
I'm not sure what I would respond to. There's no question addressed to me at this time.
Thank you. Now I turn to the senator from Johnson County, Senator Olson.
Thank you, Mr. Vice President. I have a question, and the question is for you, actually, or the President. The way I see this bill under the Constitution, it takes 27 votes to pass it. I want to know what the chair plans to do when he rings that gavel. Is he going to deem it passed at 21, or is it going to need the constitutional majority of 27? That's my question to you.
The president plans to make a ruling based upon the vote if it's 21 or more, acknowledging that it's not 27, and we'll proceed on with the process.
So that would deem it passed at 21. You know, I think we've heard some great arguments from the senator from Cherokee, senator from Brown. I definitely believe it'll be a violation of my oath. I can't support that. I mean, we wonder how this country's got to where it's at. It's the procedures like this that are getting us there. And you know, you heard the senator from Brown just state, if we don't like the 2/3 majority, we can change it. What's going to happen the next time and the next time? The bills that the people that vote for this don't like and come and don't need the 2/3 majority. We're going to erode that. We've done it in the U.S. Senate. Now we're going to do it in the Kansas Senate. Mr. Chairman, I'm going to make a motion to send this bill back to committee. And so that's my motion.
Motion is in order, and it is debatable. Is there a Senator from Cali, Senator Alley, response?
Thank you, Mr. Chair. I do have one question. We've heard a lot today about history. We've heard a lot today about Constitution. We've heard a lot today about the rule of law. But I would like someone to answer the question that I have just received, and that is, how many chambers passed our Kansas Constitution? If no one in the chamber can, I'll ask the revisor. Hang on.
Are there other questions? Senator from Johnson, Senator Thompson.
Thank you, Mr. Chair, Mr. Vice President. I was actually just going to make remarks based on the base bill and not this motion. So I'll reserve my comments and see where we go from here. Thank you, Mr. Vice President.
We'll stand at ease, change chairs.
Point of order.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. We have a motion on the floor to send this back to committee. I appreciate the question from the carrier of the bill, but I really do not see how that is relevant to the floor on the motion that is on the floor.
Motion to send back is in order. It is debatable. So my understanding is we're on the motion to send it back. It's being debated, and the senator from Cali had a question or a comment. Senator from Cali.
Yes, thank you, Mr. President. My question was, how many chambers passed our original Constitution?
Senator from Cherokee.
Again, Mr. President, the motion on the floor is to send this back to committee. In the spirit of debate, I am not sure what that question has to do on the motion to send it back to committee.
Senator from Cali, is the question to solidify in your mind whether or not to vote for the motion to send it back? Is it go to the question?
If I may, Mr. President, the
Senator
reason
Cali.
I asked that question, we've heard a lot about Constitution up here today. We've heard a lot about the rule of law. The question to send it back to is a motion to kill this bill. We haven't even heard a closing argument. And we want to send it back to, with one day left in our session this week. The reason I ask this is because we did not pass both chambers when we adopted our Constitution. It was passed by the House, and we just adopted in the Senate. Wyandotte Constitution. We've talked about rule of law, but we didn't even pass our own Constitution with both houses. So let's continue this debate. We've heard 2 or 3 hours worth of debate with nobody else talking. So I would prefer to ignore this motion and continue the debate.
Was the motion yours, Senator from Johnson, Senator Olson?
Yes, it was. I just want to state I wasn't here back when it was passed. So I'm not sure. I'm not a history major, but I am aware that 68% of the Kansans in the 70s voted for this. And it's in the Constitution. I take an oath to the Constitution. I think we need to take and send this back to committee. I think what we're doing is going down a bad path that we've seen other places go down. And I just pray and hope Kansas don't go down that same direction. I'm trying to give some people an opportunity to save faith, take another look. Maybe if we don't want the 2/3 majority, run a constitutional amendment next year, and let's do away with the 2/3 majority. You know, we passed a pro-life one to put on the ballot. That took a few years. We had 26 votes on this, I believe, last year. So, me, I think we're going down a bad path. I don't know if that answers his question, but I wasn't here when they did it.
Further discussion on the motion, Senator from Leavenworth, Senator Pittman.
Thank you, Mr. President. Appreciate that. I think we're going down a very bad path when we start questioning whether we're going to follow our Constitution because we didn't pass it through two chambers. I think that's a very bad path. We swore an oath. If we had a problem with that, then don't swear that oath. When our military goes out and fights on our behalf, they took an oath to our U.S. Constitution. We ask which chambers did it pass. I don't think that is a solid line of argument, and it's borderline what I think we should be willing to accept as an argument here. No offense. I think this is a good idea. I think we should specify in the resolution what our expectation is. We should put inside in the committee, when we push this back to the committee, that it needs 2/3 as is specified in our Kansas Constitution. I think that's a good motion inside that committee, and then bring it back out. We know we can work fast in this committee. It doesn't need to die. We don't know that Thursday is our last day. I think it's a very viable thing to do, or amend that 2/3 into that resolution today on the floor. Either way, we as a body can specify our expectations to the chair and prevent a lengthy legal process. And then in the long run, if that did happen to fail, we could change the Constitution on this. But I think if we're going to do this, we need to have a clear will of the people. And getting by rules to get this thing passed does not seem to be a legitimate way to do something that's seen as a very serious move for our state to make. Could be valid at this time if all the votes are here. So I think we should move it back, put our expectations in, and then try it again on the floor to see if it really is the will of this body. Thank you, Mr. President.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. And I just want to clarify something. The good senator from Cali says that he just received a question from somebody. I'm assuming it was via text or via email. I can tell you who it came from. It's my friend, and I won't repeat his name. But I want you to listen to what his question was, everybody in this chamber. How many chambers passed that amendment? It was worked in the House, passed out of the House, and adopted by the Senate. Then the question, or a little bit of, I don't know, history was that it was adopted during the Wyandotte Convention. The Wyandotte Convention, I believe, was in 1759. This amendment happened in 1974. So going back to the question, it was worked in the House, passed by the House, but only adopted by the Senate, trying to allude that this chamber did not vote on that amendment. So I ask, what does adopted mean to the senator from Cali when it was adopted by the Senate in 1974?
Is this the question to return it back to committee? Or are you asking a question to the guy that answered the question to you? We're circulating a little bit, right?
I apologize, Mr. President. If the good senator from Cali wants to answer it, he can. If not, I would be more than happy to answer it because it was not a, I know the answer to that question that I asked, so.
We'll leave it rhetorical then.
The Senate had to vote on it to adopt it. Thank you.
Senator from Johnson, Senator Thompson.
Thank you, Mr. President. There's a lot to cover here. We've heard a lot from a variety of people, all eloquently stated. This debate is coming down the tracks, whether we like it or not, whether we agree on the rules or not. We could send this back to committee. It's eventually probably going to come back out here, and we're going to be facing the same thing. Will we vote to override the Kansas Constitution? That's not really the question. The question is, we are looking at amending the U.S. Constitution, and the Supremacy Clause is what determines that. And the Attorney General's opinion on that, I believe, is valid. We've got patriots in this room. There's no doubt about it. We've got people who see the problems coming down the pike. We began to lose our state's rights in 1913 when we passed income tax, 16th Amendment, 17th Amendment, when popularly elected senators, U.S. senators took over. Prior to 1913, when that was adopted, the states had the ability to recall our senators. That's where we appointed those senators. And if we didn't like what they were doing, our constituents could come to us and say, hey, this guy's doing a terrible job. Recall him. That's when the state legislature really had power. Since 1913, actually one president wiped out a lot. Woodrow Wilson, 16th Amendment, 17th Amendment, started the Federal Reserve with the hyperinflation that we're on the verge of right now. We've got Senator Hildebrand, Senator Cherokee, Senator Hildebrand articulated all the problems eloquently. We've got a lot of problems. And I think there are a lot of people, grassroots people, as he articulated, who worked for me on my campaign, who worked for many of our campaigns, who are absolute patriots, who see these problems, and they see more of an urgency than a lot of us do, because we are in a position to fight those fights every day, but they're not. These people don't see any other way. Pragmatism can make us reticent to act. I think we all have the end goal in mind is we have to rein in this out-of-control government. And how do we do it? Do we try to do it through the system? Or do we look to Thomas Jefferson's words saying that the tree of liberty must be refreshed from time to time by the blood of patriots and tyrants? Do we want to go that far? No. We want a peaceful way to amend this, to fix the problems that we've had. We've lost states' rights. And if we don't recognize that, then we're more blind than we realize. And I see this as a way to do it. And if we have to go through the Supremacy Clause to do it, then you know, it is, like I said, none of us disagree. I don't think that the federal government's out of control. It just comes down to the proper path. And I don't see the Supremacy Clause as violating my oath. I took an oath when I served in the Navy to support and defend this Constitution. I took the oath here twice now, and I intend to support that Constitution in any way I can. And we're talking about amending the U.S. Constitution. The Supremacy Clause, as the AG said, is correct, is a correct path. And I won't belabor the point anymore, but I think that this debate is coming. We can avoid it, we can push it down the tracks, but I guarantee over the next year or so, with H.R. 1 coming from the federal government, vaccine passports that we haven't been able to take care of yet, we've got school children being isolated because they decide, their parents say, don't wear masks. have 2 of them in my district alone that have been thrown into rooms by themselves. We don't have a mask mandate, and yet these masks are being pushed on these kids and causing all sorts of harm. Hyperinflation is coming. The Federal Reserve is out of control. We have so many problems that we can't fix at the state level. I don't know where we go other than something like this. I understand people have concerns about the potential of this turning into a real problem. I understand both sides of this argument 100%. But I fall into the more urgent camp. And so I would tend to not support the motion and continue this debate and see where it goes. Thank you, Mr. President.
Further discussion? Senator from Johnson. Senator from Johnson. Oh, sorry. Senator Warren. Multiple senators from Johnson. I probably apologize.
Thank you, Mr. President. Like you, I'm a senator, I'm a colleague of yours, and like you, I'm going to be asked to vote on the motion whether to send this resolution back to committee or not. And I've listened to the debate, and I consider myself one of those patriots that the other senator from Johnson, Senator Thompson, referred to. There's been a lot of question floated around about whether a vote of less than 27, but 21 or more would be appropriate to consider the resolution as passed. So I look at our oath of office, and our oath of office does require that we swear or affirm to support the Constitution of the United States and the Constitution of the state of Kansas. And you'll notice that the Constitution of the United States is listed first in our oath. In our oath of office, we are sworn or affirming that we will support the Constitution of the United States first. And that is because of the supremacy of the United States Constitution. For that reason, we look then at the United States Constitution in Article 5. I know we've been talking about it a lot today, and it's appropriate because this is a convention of states regarding the power vested to the legislatures in Article 5 of the U.S. Constitution. It's important to look at the language of Article 5 in the Constitution of the United States, as it is when we're looking at any law. The rule of law is important and the written word is important. And in Article 5, it says that the convention of states may be called on the application of the legislatures of 2/3 of the several states. And I want to preface this, I'm not persuading a vote either way, I'm just explaining my vote to you, fellow senators, as one of your senators. So it says on the application of the legislatures. The legislatures. And I believe in government, we are of the people, by the people, and for the people. Keeping that in mind, though, the written word of Article 5 of the Constitution of the United States says on the application of the legislatures. When the Kansas Constitution was amended in 1974 to add the requirement in the Kansas Constitution for a 2/3 majority of the members to make application for Congress to call a convention for proposing amendments to the Constitution of the United States, that amendment in 1974 was a restriction or limitation put into our Kansas Constitution, not by the legislature, but by the people, because it was put to a vote for either ratification or not ratification to the people of the state of Kansas. And it sounds unusual or contrary to say that the people of Kansas, when they voted in 1974 to amend the Constitution, that they didn't have the authority to do so. And they didn't have the authority to do so because of the supremacy of the United States Constitution. That is because Article 5 of the United States Constitution says, the legislatures shall decide whether to make application for calling a convention of states. Section 13 of Article 2 of the Kansas Constitution wasn't a restriction made by the legislature, but by the people when they put on the 2/3 majority requirement. Again, that sounds odd that, well, it's the people, shouldn't they have the ultimate power? Well, the people can only exercise the power that the United States Constitution in Article 5 gave them. Now, Article 5 of the United States Constitution was silent on what kind of vote would be required by the legislatures to make the application to call a convention of states. So we have to then look at the legislatures and what the legislature's rules are. So the people can't exercise an authority that they weren't given by the U.S. Constitution. The legislature does have authority from the U.S. Constitution in Article 5 about making an application of the legislature. So I'm thinking then we look at our Senate rules. And our Senate rules then, because the Senate rules are made by the legislature. The House rules are made by the legislature. The joint rules of the legislature are made by the legislature. So if our Senate rules made by this legislature state that a simple majority is required, or that a two-thirds majority is required, that, to me, in my mind, would be where the vote requirement lies to determine that this resolution is passed or not passed. We have the power as a legislature. We could have changed our rules when we voted on them when session began, and we could have voted on them as they were presented to us, and we did. We voted on them. Those are the rules of the Senate, and those rules apply even in this instance, and especially in this instance when we're looking at Article 5 of the Constitution of the United States, which, as it's been stated by the other senator, one other senator from Johnson, Senator Thompson, that we do have the closest thing that we have to a decision about, well, is the argument correct that the supremacy clause of the United States Constitution prevails and Article 5 is silent on the in the U.S. Constitution on whether the two-thirds majority in the Kansas Constitution prevails or it doesn't? The closest thing we have to a determination on that issue is the Attorney General's opinion from 2019. And the opinion talks about that the supermajority requirement of the state constitution cannot bind the legislature when the legislature is exercising the federally delegated power of applying for Congress to call a federal constitutional convention under Article 5. And the opinion goes on to explain that that's because the people, when they ratified the amendment to the Kansas Constitution to require a two-thirds majority, they didn't have the authority to do so. And that authority has not been challenged yet in court to determine is the Kansas Constitution correct or not, which is why I believe that the challenge may be coming in court that we've been hearing about here on the Senate floor if the resolution were to pass both chambers or one chamber, or I'm not sure. But so it's important to consider that one other court, not in Kansas, but another court, let me back up a minute. A similar question was brought up in Ohio, for instance, and we had a ruling from the Supreme Court that could the people of Ohio reserve that power not given to them by the United States Constitution? And the answer was no. So again, it sounds to our minds, right, is odd that, well, you know, of course the ultimate power lies in the people. Well, when the United States Constitution was, we have the supremacy clause of the United States Constitution, and that power was not given to the states, so, or excuse me, to the people of the states. So it would not be binding on this body, on this legislature, the 2/3 requirement in our Kansas Constitution. I know that sounds counterintuitive, but if you go back and look at where the 2/3 majority comes from and what authority it had to be enacted in the first place, or more importantly, didn't have, it leads to the conclusion that because Article 5 of the U.S. Constitution delegates the authority of application to the legislatures, that then we look at what the rules of the legislature are and not what the people who didn't have the authority to restrict the power of the legislature did in the constitutional amendment in 1974. And I want to read the conclusion of the opinion that was handed to us by the Attorney General in 2019, that it's this. In conclusion, the power to apply for Congress to call a constitutional convention to consider amendments to the United States Constitution is a federal power granted to the Kansas legislature by the federal Constitution, which cannot be constrained by the people of Kansas through the text of their state constitution. Consistent with Article 5 of the United States Constitution, and notwithstanding Article 2, Section 13 of the Kansas Constitution, the Kansas legislature may determine for itself the number of affirmative votes required to exercise the federally delegated power to apply for Congress to call a federal constitutional convention. This legislature has decided for itself, and it has done so and so spoken in the Senate rules. So as long as the rule from the chair on whether the resolution is has a constitutional majority to pass, as long as that is consistent with our Senate rules, that would be consistent with the United States Constitution and not be a violation of our oath to uphold the United States Constitution. Thank you.
Senator from Leavenworth, Senator Pittman.
Thank you, Mr. President. I think that was a good attempt at a long, twisted path of rationalization in my mind. No offense intended once again. It was well done in a lot of ways. You know, our constitutional measures that we put on the Constitution as amendments are suggested by the legislature. They pass the legislature, as we have done this year, as we all know early in the session. And then we put those to the people to make that final decision. To pass those amendments out to the people, to have them vote on those things, does not mean the legislature did not weigh in on those measures. To imply that the people, to take away the power of the people and the power of our Constitution, our state constitution, the fundamental law of our land, and say that our Senate rules override that because we've decided that, I think that's a far reach of interpretation. I think it's clear that if we really want this, and we all did agree, as the good senator from Johnson implied, that we all agree with his position that everything in the federal government is a runaway train and we need to act now, then this will pass with the required majority. And I think that's the intent of this Article 5 is when we feel it's that bad, as a state, we're going to jump on board. And it sets a threshold high enough inside of our Constitution, say, but we don't want to jump in too fast. We don't need to lead the charge. We don't need to be out there on the cutting edge trying to make rulings to get this thing passed outside of our Constitution. I think this is a good measure to move this back to committee, put in there a clear definition of how many votes we need, and vote on that. I just differ with my interpretation that the legislatures, that the Article 5 U.S. Constitution is defining that so narrowly that our rules of the Senate are the only thing that would determine that success factor. I think a constitutional amendment that had to go through the people is a clear signal from our constituents about what's expected of us and I believe we should abide by those. Thank you, Mr. President.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. I know when I got up and spoke, I spoke probably longer than anybody really wanted me to. And, but I did discuss AG's opinion. And when I discussed that, and I pointed out where I felt the errors were, I made this statement. I would agree with the AG's opinion about the citizens of Kansas dictating to the legislature on how to apply to the Constitution or a constitutional convention to apply for that. If we were a citizen-initiated referendum Constitution amendment. We are not. In the state of Kansas, the legislature decides what bills to go before the people to ratify. It is not the citizens, it is the legislature that decides that. The court case that was just mentioned in Ohio, I agree with the AG, because that was a citizen-initiated constitutional amendment, initiated by the citizens of Ohio, not the legislature of Ohio. To say the legislature did not set that in our Kansas Constitution, we did not vote on it because we then sent it to the citizens of Kansas to ratify our decision, or I wasn't here in 1974, but this body's decision of 1974 is the citizens dictating to the legislature how they will call it. I disagree. You know, I will tell you, I did some research before the rules, we voted on the rules. Because I started hearing rumblings of the COS trying to do this to change the rules. And when I looked at it, the Senate doesn't have rules. We don't need rules. We have the Constitution. We take an oath of office for the U.S. and Kansas Constitution. And in our Kansas Constitution, by amendment in 1974, that was passed by the Senate and the House in 1974 legislature, to send it to a ballot for the Kansans to vote on it and then ratify it. It was the legislature process that decided the process. It was just confirmed and ratified by we, the people of the state of Kansas. And for that, I would highly encourage everybody to vote to send this back.
Senator from Brown, Senator Pyle, you're next.
Are you sure?
No. Don't give me another choice.
Well, I can wait if you're in doubt. Every morning, Mr. Chairman, I walk into this building and I read the power, all political power is inherent in the people. Our founders understood that. They were scared to death of the judiciary, if you read the history. We've heard a lot about that, and that's where this is we're trying to send this back to committee, I guess. We're going to vote on that, hopefully, some point. Send it back to committee. I would hope the committee would just get it and put a constitutional provision in. Do that tonight. Get it done to change our Constitution. We'll bring it back. We'll have that debate. We'll get it to the House. House can pass it out. We need 2/3. We got to follow the rules. Let's let the people vote. We can put it on the ballot. We can pick any date we want, pretty much. We could pick a special election, or we could just pick, regular fall election, whatever, and then wait, and then go through the proper channels. And if we want to vote on the COS, come back and vote on it if those rules are changed by the people of Kansas. There's a lot of reference to the U.S. Constitution. Let's go back further. Let's go to the Declaration of Independence. When in the course of human events, and this brings, it's me emotional when I read this. I can't believe the wisdom that was put on paper. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed. I won't read any further, but I heard a statement that people didn't have authority to make the change to the Kansas Constitution. People are supposed to have the authority. That's the problem why the COS and everybody's fighting. The people are losing their power. That's the whole point. People are losing their power. It's taken away incrementally. It's been taken away incrementally. Federal government's taken it. It's taken it away from the states. It's taken it away from the people. You can argue all day on that point. But we are here, and we are supposed to be receiving the consent of the governed, and that's the people. The people passed the Kansas Constitution Amendment that said and required 2/3. Mr. Chairman, I did not take an oath to the Senate rules. I took an oath to the Kansas and the United States Constitution. And to stand here and hear people say that they're going to vote based on the Kansas Senate rules, you talk about abuse of power, let's get that list. I'm making a formal request that the Secretary of Senate get us a list showing us what the rules and the consequences and how we go about anybody that abuses their power, anybody that violates their oath to the Kansas Constitution, because we need to know. Because there are likely going to be actions.
May I remind you, we're on a motion to
I
send
know
this back.
that.
Okay.
And these are the very reasons it needs to go back to committee. So that if they want to bring it in a legitimate way, so that the legitimate purpose is to pass it with 2/3, fine, change the verbiage and let's get it done. But if your attempt is to do it to get litigation and cost the people of Kansas, then let's send it back to committee. Let's do it either way. I'm going to support the motion, but the people have the authority. And that's where, when you read the Declaration of Independence, we can all go back even further. There's the Northwest Territory Papers, there's others we can read. But we are here to do the people's business. We are their elected representatives. We are not here, we're supposed to be here to represent the people. And I said it earlier, I've got people on both sides of this issue. Some would not want me to send this back, some would. Mr. Chairman, we're here to do people's business and to do what the consent, anyway, I've said enough, but I am so grateful that there were people that knew how to put this down. And you know what? When they wrote this, they didn't have a Senate, they didn't have a House. They formed a government. And they've changed it over time because the people consented to that change. We have the power to take it back. The power lies with this body to send it back to committee. The purposes, if we want to bring it back corrected, or to bring it back with an amendment to the Kansas Constitution. I personally don't really, I could vote for something to lower the 2/3 because I've had constitutional proposals that I would like to see passed. And it's a lot easier to get 21 and 63 than it is to get the 2/3 majority of each chamber. So that's a policy decision. Thank you, Mr. Chairman.
I'd like to remind the body, we are on a process motion. We're not debating the issue right now. We're on the motion to send it back to the committee. I'd like to see us stick with that issue. The senator from Shawnee, Senator Cluse.
Thank you, Mr. Chairman. So would it be in order for me to ask the Senator of Cherokee Senator Hildebrand a couple of questions?
Probably not. I'll rule no.
Mr. Chairman, can you repeat what you just said prior to my question?
Yes, I said we are on a process. The motion is to send it back to the committee. We're not here to debate the issue of the bill or the resolution at this time.
Then I'll have to sit down.
The senator from Johnson, Senator Warren.
Thank you, Mr. Chairman. We can have feelings all we want about whether there's authority to do this or that, but our feelings in this matter about the process of whether the motion should be sustained or voted for or for against the motion to send it back, our feelings about whether what the Constitution says of the United States or the Constitution of the state of Kansas says don't matter. We have to look at what's written. And I'm going to speak to the motion because the motion seems to be coming up because there seems to be a question about, well, we need to send this back to committee because we aren't sure whether we need to follow the rules of the Senate, which say 21 or more is needed to pass the resolution, or we need to look at Article 2, Section 13 of the Kansas Constitution, which says 2/3 majority. And again, it may be our wish, our feelings, our hope that when the Kansas Constitution was amended in 1974, that the people had the authority to ratify or reject what the legislature put before them to amend the Constitution. We have to look at the rule of law. And the law, as for specifically the application of the states for a calling of the Convention of the States in Article 5 of the U.S. Constitution, says it shall be application of the legislatures. So the argument, well, it was an action of the legislature in 1974 when we amended the Constitution to require 2/3 majority. Well, no, it wasn't. It was the decision of the people, not the legislature. There's a difference because the people could have rejected the amendment or the people could have accepted the amendment and they voted to accept it, which, again, it sounds contrary to a lot of the discussion here today, but ultimately we have to look at what is written in law. And that's what I'm doing when I look at the U.S. Constitution, Article 5, and the Kansas Constitution that's at issue here. If the people had the authority to accept or reject what the legislature had put before them in 1974, that wasn't the legislature acting, that was the people, but they didn't have the authority to do so because the U.S. Constitution, in this very narrow context of making application for the calling of a constitutional convention, didn't reserve that power for the people of the states. So then we again have to look at the legislature. This chamber, the Senate rules, I believe, are silent on making application to Congress to call a convention of the states. The other chamber, the House, has different rules, and that's okay. Because the legislature decides on making this particular very narrow application. And we in our oath are required to abide by the lawful application of the U.S. Constitution. And again, that has supremacy in this context in Article 5. So again, it sounds unusual to be that the people don't have authority in this context. We are not amending the federal Constitution if the resolution ultimately passes. The resolution just authorizes and calls for the state to be one of those states calling for a convention of states. It does not ratify any amendment or even propose an amendment to the federal Constitution. So it's, again, important to stress that the legislatures have the authority, and you can't exercise an authority that you don't have. We're not usurping the power of the people. This body is not usurping the power of the people by following the U.S. Constitution, Article 5, and you're not violating your oath by following the Supremacy Clause as required by following Article 5 of the U.S. Constitution. So it's no different than if we had if the Kansas legislature had proposed to amend the Constitution to require that you could, like the Alabama Constitution used to require separate schoolhouses for people of different races.
Point of order, I
Well-
think we're back debating the bill and not on the motion to send it back to committee.
Senator Johnson, I do understand there's a reminder there, so we'll stick to comment on why or why not the bill should be sent back to committee. Senator Johnson, Senator Warren.
Sure. I was just going to make the point that just because it's in the Constitution doesn't mean that it doesn't also violate the U.S. Constitution. Thank you, Mr. Chair.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. And yeah, this is kind of an interesting rabbit hole we're going down, but just to reiterate why we should send this back to committee, the comment was just recently stated that, and there was a contradiction. First, it was 21 in our Senate rules, and then it was silent. I just want to clarify, when you're trying to decide whether or not to send this back to committee, that there is nothing in the Senate rules, so it is silent. So you are not violating anything in your Senate rules any way that you decide to vote. And also, while you're considering on what your decision will be to send this back to committee, the comment was made that even though the legislative bodies in both chambers in 1974 passed it and sent it to the citizens of Kansas, that you actually had no say in it because the citizens of Kansas actually ratified it and they did not have the constitutional authority. I just want to remind this body, not too long ago we passed the Value Them Both Amendment, but we actually have not passed it yet because it's up to the citizens to ratify it, and we did nothing to it. It's all the citizens. Thank you.
Senator from Reno, Senator Stephan.
Thank you, Mr. President. I do want to stand up and thank the good senator from Johnson, Senator Warren, to have the courage to stand up here and give us a truthful, originalist view of the law. We have a room full of armchair attorneys today, and they're feasting on emotion. And that's dangerous. Nothing means more to me than our originalist view of the Constitution, both U.S., Kansas, and right on down the line. And sometimes when we
Point of order, we're off the motion.
I'm getting to it.
You guys, you'll wait to be recognized, both on point of order and both on response. This is, even on point of order, you need to be wait to be recognized, and then there needs to be a recognized response. Point of order is taken. Senator from Reno.
My constituents, they feel disenfranchised. This motion further disenfranchises these people. And I appreciate an honest legal opinion. I know that in the state, the Attorney General is as high as it gets. In the Senate, Senator Warren is as high as it gets. We need to listen, we need to be calm, we need to be strong, and we need to stand against this motion because it's weak. Thank you.
Senator from Sedgwick, Senator Erickson.
Thank you, Mr. President. I've listened to the debate and the discussion, and I respect a lot of what everyone is saying. And I think for that reason, that is exactly why we need to keep this here on the floor, because listening to the debates, as this being an issue that is extremely difficult for us to decide, I want to know everything that's being said and debated so that I can make an informed decision, so that I can understand the legal underpinnings, the constitutional underpinnings. There's been a lot said here, quite frankly, that concerns me as someone who does value the Constitution. The last thing I want to do is violate my oath. And we're hearing conflicting information. And I think the whole chamber needs to hear the debate so we can be clear and make the most educated decision that we can. And if we're not on the committee that hears that, we won't have that opportunity. And I think this is too important for every member to individually be educated on, listen to the debate, and make up their mind. So therefore, Mr. President, I would urge people to keep it here and not send it back to committee. Thank you.
Senator from Douglas, Senator Holland.
Thank you, Mr. President. I'll be very pithy. I remember we've had a vote on this issue before. Same number, SCR 1611. And basically this happened back in, I believe, March 8th, 2018. And the outcome of that vote was yay 22, nay 16, and I happened to be absent not voting that day. I don't know where I was at, but I wasn't there. But my point is, Mr. President, is that in the journal, that vote was recorded 22 to 16 as having failed. So what's changed? Have we changed our Senate rules with respect to this since then? I don't think so. Have we changed our Kansas Constitution since then? I don't think so. Have we changed the U.S. Constitution with regards to this? I don't think so. My concern today is that why are we arbitrarily deviating from past practices based upon this body's prior interpretation of the Constitution, the requirements to get this type of a legislative vehicle through the Senate and onto the other chamber? That's why I'll be supporting the motion to take this back, because this action itself to me is arbitrary. And my fear is that if we're supposedly pinning the Attorney General's opinion on why we're doing that today, that has no legal binding for why we're doing this today. We have established precedent. I think we need to return to those precedents if we are confused as far as how to go forward. Thank you, Mr. President.
Senator from Barton, Senator Straub.
Thank you, Mr. President. I'll make this very brief. Just looking back through some dates. U.S. Constitution, Article 5, ratified June 21st, 1788. U.S. Constitution, 10th Amendment, 1791. Kansas Constitution, 1861. Kansas Amendment, 1974. I have to agree that this is probably one of the best debates we've had on the Senate floor here, and happy to have this discussion. And not jokingly, but maybe we ought to consider a veto override of House Bill 2039. Thank you.
Senator from Alley, you've been standing, so I can't tell if you want to address or not, but if not, you want to address before we finish up the motion? Senator from Cali.
Thank you very much, Mr. President. I've heard a lot of things today. sending this back to committee is an attempt to kill the bill. We had a debate on this bill in Fed and State Committee. We had a large number of people that attended from both sides of this debate. Sending it back to committee, we'll get the same people in. It will not change the debate. This isn't about 21 or 27. This is about a process that we are beginning. And sending it back to a committee, I'm saying let's just continue this vote and see how it ends up. But sending it back to committee will not change the output. It'll just delay it.
Seeing no further questions, Senator from Johnson, you can close on your motion.
Thank you, Mr. President. All week, as I've heard, when we were in caucus earlier, a question was asked. You said it was only going to take a 21 vote margin. Definitely raised the red flag. I've been here 17 sessions, and I've never heard ever before the Senate rules, or I'm not sure, maybe the joint rules are the highest rules of the land, I guess, in Kansas. That'll be the first time I've ever heard that argument made. I've heard a lot of lawyers speak in this body and the one across the hall. You know, why did we just put it up for vote for the amendment that's coming up, or the pro-life amendment? I mean, joint rules or Senate rules trump everything. I mean, why did we put that on the ballot for the people to vote? Under this theory, it's meaningless. That vote's meaningless. I guarantee you the people across the street don't believe the Senate rules are higher than the state constitution. I guarantee you the people of Kansas don't think so either. And they sure don't think the joint rules are higher than them either. I think we've gone off the rails here. I think we're endangering our future to operate on a normal basis when we start playing games with the rules. Why did the past president, it got 26 votes and it was deemed unconstitutional? How many times have I seen it deemed unconstitutional? I mean, why didn't we use the Senate rules on the override and just say it takes a majority? Mr. Chairman, I'm going to leave this up to every senator because it's their vote. The people vote for them and give them the power to make this decision. But in the end, it probably won't be the final decision made by us. It'll probably be made, if this is deemed constitutional and gets 21 votes and moves out of here, there's probably some of us going to file a protest petition. Never done that before. Heard about it a lot over the years. But I already know there's one ready to go. I'm probably going to try to vote along with other members to not agree with the chair or the president on the ruling. I think it's a sad day, I really do, that we're trying to move something through on a majority vote that takes a clear constitutional majority to pass out of this body. And when we start playing games with the rules, we're going to be no different than them guys in Washington, D.C. It's a mess up there. It's a madhouse. We get this judge through. We just do, you know, one side did it, now the other side. Now let's add some judges to court, or I'm not saying what's right or wrong, but when you start playing with rules. And I think Senator from Brown, Senator from Cherokee, a lot of people in here made some great points. I hope everybody really thinks about them, because the people, the Kansas Constitution is too important to just throw it away and say, now we're going to go off the Senate rules. We're going to go off the joint rules. So I think there's plenty of time. This bill will not be dead if we send it back to committee. If you want to change the majority to a simple majority, do it. Do it the right way. Pass that out. Allow the will of the people happen. I'll vote for it. To just get it on the ballot and see what the will of the people will do. Because I think they'll reject it. So I think there's plenty of time. This bill would go back to committee, still be alive for next year. And this issue, it's not going to be solved this year or next year. It's going to take a while. I don't want to throw our Constitution away. I took an oath to uphold it. And, I mean, I'm going to do everything I can. That's why I made this motion to send this back to committee. I've voted for this bill multiple times. But I am not going to vote for a 21 vote when it should be a 27 vote. And I'm not going to vote when people are playing games with the Constitution. I'm not going to support that. So I move my motion.
So for clarity on the motion, a yes vote sends the bill back to committee. A no vote, we continue in debate. Is everybody clear? All those in favor say aye. Aye. Opposed, no. Roll call's been requested. Seeing 5 hands. Roll call's in order. Clerk will call the roll.
Ellie. Baumgartner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Fagg. House-Cadeau. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Holscher. Kirshen. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson. Petty. Pittman. Pyle. Reichman. Steffen. Straub. Sullentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Has everybody had an opportunity to vote? Does anybody wish to explain their vote? Anybody wish to change their vote? Seeing none, clerk will close the roll, tally the vote. Anyone having voted in favor, 19 opposed, the bill returns to the committee. Chair recognizes the leader from Cali, Senator Alley.
I move the Senate resolve itself into a committee of whole for the consideration of bills on a calendar under the heading of general orders.
This is the motion to rise and report. Senator Cali, I need a motion to rise and report.
Thank you, sir. Mr. President, I move the committee rise and report.
You've heard the motion. All those in favor say aye. Opposed, no. Motion passes. Since I'm in the chair, we will break for a minute till the committee report. The clerk will read the committee report. You have a point of order?
Yeah, Mr. Chairman, I had to go, just quick, I had to go hunt for this, and this guy got it out of the Majority Leader Staff's office, and it's what contains the Constitution, the first part of the statute set. But we don't have complete sets over here, and I noticed that last year also. Well, then people need to return the pieces back, because I went to both sets looking, and it's gone from both sets. So I just ask that we could maybe check and make sure we have 2 full sets sitting out here. Please, thank you.
It's not technically a valid point of order of the calendar, but duly noted, and we will get that in place. Clerk will read the committee report.
On motion of Senator Alley, the Senate resolved itself into the Committee of the Whole for consideration of bills on the calendar under the heading of General Orders with Senator Masterson in the chair. On motion of Senator Olson, SCR 1611 was re-referred to the Committee on Federal and State Affairs.
Chair recognizes Senator from Cali for adoption of the committee report.
I move we adopt the committee report.
You've heard the motion. All those in favor say aye. Opposed, no. Motion passes. We'll refer back to that order of business, introduction of bills and concurrent resolutions. The clerk will read.
Senate Bill 314, an act reconciling conflicting amendments to certain statutes.
This constitutes Senate Bill 314. This time I'm referring 314 to the Committee of the Whole. At this time I am appointing Senator from Miami, Senator Baumgartner, to replace Senator from Lyon, Senator Longbine, Senator from Sedgwick, Senator Erickson, to replace Senator from Montgomery, Senator Peck, Senator from Johnson, Senator Sykes, replace Senator Johnson, Senator Holscher, as Senate conferees on House Bill 2134. Are there announcements? Senator from Sherman, Senator Billinger.
Thank you, Mr. President. We'll have a conference committee tomorrow at 9 o'clock, Senate Ways and Means, in room 112 North, appropriations. Thank you.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. And what better thing to do than after a long, hard debate with the legislative prayer breakfast tomorrow at 7 a.m. in room 142 South.
Senator from Lynn, Senator Tyson.
Thank you, Mr. President. The information desk wanted me to let people know downstairs that there was a bracelet found. It's a very nice bracelet. It was found in the parking garage. Thank you.
Listen, we already have an owner. Further announcements. Seeing none, Chair recognizes the Senator from Cali, Senator Alley.
Thank you, Mr. President. The House and Senate Fed State Affairs Committee will meet at 8:30 in the morning in room 144 to continue the conference committee. I move the Senate adjourn until 10 a.m. Thursday, May 6, 2021.
You've heard the motion. All those in favor say aye. Opposed, no. Senate's adjourned.